This number two.
Property tax matters, my lords. The circular has been challenged. There's a threat of closure to the schools.
Tomorrow.
Similarly placed matter, my lords.
FR number, is it? Only FR number matters can be moved. Rest online.
My lords, we had moved a memo yesterday, my lords. My lordship had taken it. It was numbered yesterday. All the objections have been complied, but unfortunately, it's not
Fresh
on the list.
matter.
Fresh matter, my lords.
Oh, no. Oh. Tomorrow.
May I pray for it for end of the list or tomorrow, my lords?
Tomorrow.
Yesterday I moved, my lords. It has directed to be listed today. Unfortunately, it was not listed. My lords.
Fresh.
Tomorrow, fresh minute.
Tomorrow.
Now, similarly placed matter, my lords, we had moved it yesterday. We had complied with all the office objections, my lords. My lords, there's a threat of imminent recovery by the BBMP, my lords.
Tomorrow.
Wait for my lords.
Lord, serial number 37.
Just wait.
Adjournment, page wise, list number 1, page number 1, serial number 1 to 7. Page number 2,
Lord, it's been timely, Lord. 2 weeks time.
Which matter?
WP 1273 of 20.
Which serial number?
First year.
serial number 2.
Serial number 1.
Serial number 2.
2 weeks.
You want time?
2 weeks.
At request. List the matter. When do you want?
2 weeks.
2 weeks.
Single council not in station.
Week after next. You have to enclose show cause notice.
Please.
Make a note of it.
Serial number 9.
Page number 2, serial number 8 to 14.
Serial number 9, madam. A week's time.
Your Honor, I am the petitioner. I object for this.
Serial number 9. List 1.
I am for the petitioner. Srinivasan.
Huh?
I'm sorry.
WP number 2768. 2768.
Week's time.
At request. List the matter next week. The date code, preliminary hearing.
Serial number
22nd.
Serial number 11. Kindly have tomorrow.
11.
Yes, sir.
Relist tomorrow.
Page number 3, serial number 15 and 16. Page number 4, serial number 17 to 23. Page number 5, serial number 24 to 28. Page number 6, serial number 29 to 34. Page number 7, serial number 35 to 41.
37, my lord.
Yes.
37, my lord. Next week, my lord. I'll file the withdrawal. Week's time may be granted.
Next week.
Next week.
At request.
37.
Relist the matter next week. Date code.
23rd.
My lord, serial number 41, applying for respondent 2 and 3, my lord. Praying for 2 weeks of time, my lord.
Final disposal, it is 2015 matter. Why we should give
Serial
time?
is in the town, my lord.
2015
Final
matter.
accommodation.
Huh? At request, relist the matter on date code.
25th.
Both sides to file synopsis after serving advance copy on the
25th.
other side.
List number 2, adjournment, page number 1, serial number 1 to 4. Page number 2, serial number 5 to 8.
Serial number 7, my lord.
Yes.
Maybe 7-2 may be given for
Weeks time granted for compliance finally. Next.
much obliged.
Page number 3, serial number 9 to 15. Page number 4, serial number 16 to 23.
Number 17, my lord, I am for the petitioner. Dispensation IA has been filed, my lord, to dispense with the production of annexure B, my lord. Original is with me, my lord, I got it. I will do the needful, my lord, I will
Have you informed the other side?
inform, my lord.
You
The
have to-
BBMP, my lord, they are representing R4 to 11, they are appearing, my lord. In fact, 1 to 3 notice is yet to be ordered, my lord. There is an interim order granted by this lord on one court, my lord.
No, but you correctly inform and then report to the court office.
Please, my lord, I will inform, my lord.
Because in my code, you have to
Please, my lord, I
inform
will inform, my lord.
in advance itself.
Please, my lord.
This is the matter week after next.
Interim order may kindly be extended.
Interim order earlier grant is extended to the next date.
My lord, appearing for R1 and R2, no objections, my lord.
This is the matter week after next date code.
6th of February. Page number 5, serial number 23 to 30.
30, my lord. I pay for the petitioner, which time may be granted, my lord. I'll inform the other side.
You have informed.
Yes, my lord.
At request, this is the matter week after
Interim order
next.
kindly be extended.
Interim order earlier grant is extended till the next day.
Page number 6, serial number 31 to 36.
35, my lords,
Yes,
will be taken in the next week, my lord. I will inform the other side also.
you have informed.
I'll inform them, my lords. I'm not-
You have to inform advance in my court.
I will immediately do it. my lord. Next week, positively, I'll go ahead with the matter.
At request, release the matter on date.
25th.
No, my lord, I issued the notice to stop the construction.
Fresh matter or old? No.
One fresh matter. The date was fixed on 9th of January, but it was not listed. Any date, my lordship, this week.
Case number 1, fresh hearing matter, serial number 1. Ekam Vikanna.
I appear for petitioner.
Yes.
Petitioners have questioned the demand notice issued by the respondent BBM.
You will have to file an appeal. That's the order I passed in all matters. All matters I've been following.
Previous 7 years, they have demanded.
Which is that beyond 5 years you point out? Which is the one beyond 5 years you point out?
Beyond 5 years is 2016, 17 and 17, 18 for the assessment year.
Annexure?
Annexure C, so called notice C1.
You have a look at it, I'll pass over. Have a look at it. Same order. Pass over. Give him a copy.
Serial number 2, urgent. Serial number 3, Anant Narayan BN.
I represent petitioners. Petitioners application for approval of signed building plan for construction on their property.
Take out notice. AG accepts notice for the first respondent. Any standing council, Kanakpura Planning Authority. Planning Council Yogesh Nayak is directed to accept notice for the second respondent, emergent notice to the third respondent.
Serial number 4, Mohan Kumar D.
Gave representation to the concerned authorities. Till today, they are not responding for e-Khata extraction. Page number, my lordship.
Chikbalapura, Gram Panchayat. Learned Council MS Devraj accepts notice for the third respondent. AG accepts notice for respondent 1 and 2. List the matter in preliminary hearing list week after next week.
30th.
30th. They are asking for e-Khata. Mandamus they seek. You want earlier date or 30th?
Serial number 5, SP Ramesh.
This petition, my lord, petitioner has challenged the notice issued by the fifth
It's
respondent.
only a show cause notice.
ಇಲ್ಲ ಸರ್ ಸೋಕಾಸ್ ನೋಟಿಸ್ ಏನು ಕೊಟ್ಟೇ ಇಲ್ಲ
No, no.
ಎವಿಕ್ಷನ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಫಿಫ್ತ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಎಕ್ಸಿಕ್ಯೂಟಿವ್ ಆಫೀಸರ್ ಇಶ್ಯೂ ಮಾಡ್ತಾರೆ
The annexure N.
Annexure N and Q.
N is only a notice.
Notice.
What is wrong with it? You go and raise your.
ಅಲ್ಲ ಸೊ ಅಬ್ಜೆಕ್ಷನ್ ಎಲ್ಲ ಫೈಲ್ ಮಾಡಿದ್ವಿ ಸ್ವಾಮಿ 24th ಫೈನಲ್ ಆರ್ಡರ್ಗೆ ಹಾಕೊಂಡ್ಬಿಟ್ಟಿದ್ದಾರೆ
Ugly, what is wrong?
ಅಲ್ಲ ಅವ್ರು ದೇರ್ ಇಸ್
You can come.
ದೇರ್ ಇಸ್ ನೋ ಅಥಾರಿಟಿ ಟು conduct or initiate proceedings against the land bearing survey number 283 situated at Alsbalu village Saklesh Pratala.
Why?
ಅದರಲ್ಲಿ 4 ಎಕರೆ 10 ಗುಂಟೆನ ಮನೆ ಇಲ್ದೇವ್ರ ಸೈಟ್ಗೋಸ್ಕರ ರಿಸರ್ವ್ ಮಾಡಿದ್ವಿ ಅಂತ ಹೇಳಿದ್ರೆ ಅದರಲ್ಲಿ ಆಲ್ರೆಡಿ ಮನೆ ಕಟ್ಕೊಂಡ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಫೋಟೋನೆಲ್ಲ ಹಾಕಿದ್ದೀನಿ ನಾನು ಎಲ್ಲಿ ಲೆವೆಲ್ ಮಾಡಿ ಕಾಫಿ ಎಲ್ಲ ಎಷ್ಟೇ ಇದ್ ಮಾಡಿದೀನಿ ಅಲ್ಲಿ ಬಂದು ಎನ್ಕ್ರೋಚ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ ಹೇಳಿ ಸರ್ವೆ ಮಾಡಿದ್ದಾರೆ ವಿತೌಟ್ ನೋಟಿಸ್ ಟು ದಿ ಪಿಟಿಷನರ್.
No, this notice is of the year 22 you are challenging now.
ಅಲ್ಲ 22 ಇದೆ ಸ್ವಾಮಿ 24th of this month ಫೈನಲ್ ಆರ್ಡರ್ ಇಟ್ಕೊಂಡು
Maybe the notice is
subsequently annexure Q also issued, my lord, on 13/11/2023 page 97. Petitioner Sangu kuda issue ಮಾಡಿದ್ದಾರೆ ಸ್ವಾಮಿ.
it's only a notice. You make your case out, they will decide.
ಅಲ್ಲ ಅವ್ರಿಗೆ ಅಥಾರಿಟಿನೇ ಇಲ್ಲ ಇಶ್ಯೂ ಮಾಡಿದ್ದಾರೆ ಅಂತ ಇನಿಷಿಯೇಟ್ ಕೈಂಡ್ಲಿ ಸಿ annexure M mile after this issuance of this two notice. Tahsildar issued a letter on 16/11/2022 to the Assistant Commissioner Sakleshpura, page 87 mile. ಸಕಲೇಶ್ಪುರ ತಾಲೂಕು ಕಸಬಾ ಹೋಬಳಿ ಎಬ್ಸಾಲೆ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 241 ಸರ್ಕಾರಿ ಜಮೀನಲ್ಲಿ ನಿವೇಶನ ರೈತರಿಗೆ ಜಮೀನು ಮಂಜೂರು ಮಾಡುವ ಕುರಿತಂತೆ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಸಕಲೇಶ್ಪುರ ತಾಲೂಕು ಕಸಬಾ ಹೋಬಳಿ ಎಬ್ಸಾಲೆ ಗ್ರಾಮದಲ್ಲಿ ವಾಸವಾಗಿರುವ ಪರಿಶಿಷ್ಟ ಜಾತಿ ಆದಿ ದ್ರಾವಿಡ ಜನಾಂಗಕ್ಕೆ ಸೇರಿದ 22 ಕುಟುಂಬಗಳು ಕಳೆದ 22 ವರ್ಷಗಳಿಗೂ ಇಂದಿನಿಂದಲೂ ವಾಸವಿದ್ದು ವಾಸಕ್ಕೆ ಮನೆ ನಿರ್ಮಿಸಲು ಸ್ಥಳ ಇಲ್ಲದ ಕಾರಣ ಎಬ್ಸಾಲೆ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 241 ಸರ್ಕಾರಿ ಜಮೀನಿನಲ್ಲಿ ಮನೆ ನಿರ್ಮಿಸುವ ಉದ್ದೇಶಕ್ಕಾಗಿ ಉಲ್ಲೇಖ 1ರಂತೆ ಜಮೀನು ಮಂಜೂರಿ ಕೋರಿರುತ್ತಾರೆ. ಈ ಸಂಬಂಧ ರಾಜಸ್ವ ನಿರೀಕ್ಷಕರು ಕಸಬಾ ಹೋಬಳಿ ಅವರಿಂದ ವರದಿ ಪಡೆಯಲಾಗಿದ್ದು ಎಬ್ಸಾಲೆ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 283 ಸರ್ಕಾರಿ ಗೋಮಾಳದಲ್ಲಿ 4 ಎಕರೆ 10 ಕುಂಟೆ ಜಮೀನು MR ನಂಬರ್ ಅಂತೆ ನಿರಾಶ್ರಿತರ ಆಶ್ರಯ ನಿವೇಶನಗಳಿಗಾಗಿ ಮಂಜೂರಾಗಿದ್ದು ಆಲಿ ಪಹಣಿಯಂತೆ ಕಾರ್ಯನಿರ್ವಾಹಕ ಅಧಿಕಾರಿ ಎಂದು ನಮೂದಾಗಿರುತ್ತದೆ. ಸದರಿ ನಿವೇಶನವನ್ನು ನಿರಾಶ್ರಿತರಲ್ಲಿ ಅರ್ಹ ಫಲಾನುಭವಿಗಳಿಗೆ ನೀಡುವ ಉದ್ದೇಶದಿಂದ ತಾಲೂಕು ಮೋಜಣಿದಾರರು ಸ್ಥಳದ ಬಗ್ಗೆ ನಕ್ಷೆ ತಯಾರಿಸಿದ್ದು ನಿವೇಶನಕ್ಕೆ ಕಾಯ್ದಿರಿಸಿರುವ ಸದರಿ ಸರ್ವೆ ನಂಬರ್ 283ರಲ್ಲಿ ಒಟ್ಟು ಸರ್ಕಾರಿ ಗೋಮಾಳ 53 ಎಕರೆ ಲಭ್ಯವಿದ್ದು ಸದರಿ ಒಟ್ಟು ಗೋಮಾಳ ಪ್ರದೇಶದಲ್ಲಿ ಸುಬ್ರಾಜು ಬಿನ್ ಸುಬ್ಬೇಗೌಡ ಹಾಗೂ ಇತರೆ ಎಬ್ಬಸಾಲೆ ಗ್ರಾಮಸ್ಥರು ಒತ್ತುವರಿ ಮಾಡಿದ್ದು ಒತ್ತುವರಿ ಪ್ರದೇಶವನ್ನು ತೆರವುಗೊಳಿಸುವ ಸಂದರ್ಭದಲ್ಲಿ ಮೂಲ ಮಂಜೂರಿ ನಕ್ಷೆಯನ್ನು ತೋರಿಸಿದ ನಂತರ ಒತ್ತುವರಿ ಪ್ರದೇಶ ತೆರವುಗೊಳಿಸಲು ಅನುವು ಮಾಡಿಕೊಡುವುದಾಗಿ ಮನವಿ ಮಾಡಿದ್ದು ಹಾಗೂ ಸದರಿ ಒತ್ತುವರಿ ವಿಚಾರದ ಬಗ್ಗೆ ಕಾರ್ಯನಿರ್ವಾಹಕ ಅಧಿಕಾರಿಯವರ ನ್ಯಾಯಾಲಯ ತಾಲೂಕು ಪಂಚಾಯಿತಿ ಸಕಲೇಶ್ಪುರದಲ್ಲಿ RA ನಂಬರ್ ರಂದು ಪ್ರಕರಣ ದಾಖಲಾಗಿದ್ದು ವಿಚಾರಣೆ ಹಂತದಲ್ಲಿರುತ್ತದೆ ಮತ್ತು ಸದರಿ ಮೂಲ ನಕ್ಷೆಯ ಬಗ್ಗೆ ತಾಲೂಕು ಕಚೇರಿಯ ಲೇಖಾಲಯದಲ್ಲಿ ಪರಿಶೀಲಿಸಲಾಗಿ ಮೂಲ ಮಂಜೂರಿ ನಕ್ಷೆ ಲಭ್ಯವಿಲ್ಲದಿರುವುದರಿಂದ ನಿವೇಶನಕ್ಕೆ ಕಾಯ್ದಿರಿಸುವ ಪ್ರದೇಶವನ್ನು ಗುರುತಿಸಲು ಸಾಧ್ಯವಾಗುತ್ತಿರುವುದಿಲ್ಲವೆಂದು ಉಲ್ಲೇಖ 2ರಂತೆ ರಾಜಸ್ವ ನಿರೀಕ್ಷಕರು ಕಸಬಾ ಹೋಬಳಿಯವರು ವರದಿ ಮಾಡಿರುತ್ತಾರೆ. ಸ್ಕೆಚ್ಚೇ ಇಲ್ಲ ಸ್ವಾಮಿ ಅಲ್ಲಿ ಯಾವ ಇದು ಮಾಡಿದರೆ ಏನು ಅಂತೇಳಿ. ನನಗೆ ಗ್ರಾಂಟ್ ಆಗಿರೋದು 1943 ನಲ್ಲಿ. ಅಲ್ಲ ಅದು ರೆವಿನ್ಯೂ ಅಥಾರಿಟಿ ಅವ್ರು ಇದ್ರೆ ಏನ ಬೇಕಾದ್ರೂ ಮಾಡ್ಕೊಳ್ಳಿ ಸ್ವಾಮಿ, ಅದಕ್ಕೆ ನಮ್ದೇ ತಕರಾರಿಲ್ಲ. ಅದಕ್ಕೆ ನಾವು ಅಂಡರ್ಟೇಕಿಂಗ್ ಕೊಟ್ಟಿದ್ವಿ Annexure P ನಲ್ಲಿ. Annexure P ಅಬ್ಜೆಕ್ಷನ್ ಫೈಲ್ ಮಾಡಿದ್ವಿ ಅದರಲ್ಲಿ. ನಾನು ಎಲ್ಲಿ 43ರಿಂದ ಎಲ್ಲಿ ಸಾಗುವಳಿ ಮಾಡ್ಕೊಂಡ್ ಬಂದಿದ್ದೀನಿ ಅಲ್ಲಿ ಆ ಜಾಗಕ್ಕೆ ಬಂದು ಒತ್ತುವರಿ ಮಾಡ್ಕೊಂಡಿದ್ದೀರಾ ಅಂತೇಳಿ ಸರ್ವೆ ಮಾಡ್ತಾರೆ. ಯಾಕೆಂದ್ರೆ ಇದ್ರಲ್ಲಿ 56 ಎಕರೆನಲ್ಲಿ ಇನ್ನ 38 ಎಕರೆ ಖಾಲಿ ಜಾಗ ಆಗೇ ಇದೆ. ಇಟ್ಸ್ ಎ ಗವರ್ಮೆಂಟ್ ಲ್ಯಾಂಡ್.
Now, in case of any encroachment as per revenue, that the Tahsildar or ADLR will have to do. How can the executive? You find out. AGA is directed to accept notice for respondent 1 to 4. Then executive officer Sakleshpura will council MS Devraj accepts notice for the 5th respondent. Relist the matter on. We'll have it on Monday. Preliminary feedback you get. By Monday,
Monday, 10 days.
Relist the matter
24th this day
in the orders list on in this date 25th.
Let us may be granted.
Let us see. Needless to state, any action by the authorities would be subject to orders to be passed by this court.
Copy.
He is saying that if at all it's for the revenue authority. That's what he's saying. So he's saying.
For a moment, kindly see page number 103. Already ಮನೆ ಕಟ್ಕೊಂಡ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಫೋಟೋ ಹಾಕಿದ್ದೀನಿ ನಾನು.
Let us see. Yes.
This is a case where the property which I
purchased in the year 1996.
Kindly pass over the matter, my lords.
You appear for?
Respondent number 2.
Who are you?
I'm the bank, my lords.
Bank.
Please.
Bank is no way concerned with the present dispute, of course. I have not made them as a party to the case also.
Please, my lords,
Bank
he is
ಇದೆ.
party ಇದೆ.
VSSN bank.
ಇದೆ. Respondent number 2 is a bank.
Well, bank ಅಲ್ಲ society, sir.
Society ಅಂತ ಹೇಳ್ಬೇಕು.
Society, it's not a bank.
Society ಅಂತ.
My lord, it is covered by a decree of declaration by me before the competent civil court.
Why are you seeking for passover?
My lords, senior is engaged in this matter, my lords.
2:30, it may be had at 2:30.
2:30.
ಅಲ್ಲ, my lords, request.
Huh?
Ordered matter the content.
Huh?
This matter is being adjourned from time to time. Very simple matter.
ಅಲ್ಲ, ಇದು.
At 12:30, you come at 12:30.
Please, my lords.
Both.
Very simple matter.
12:30. 12:30.
12:30.
Total 17 on tender matter. Government
ಅಲ್ಲಿ
matter.
ಎಷ್ಟು ಗಂಟೆಗೆ ಬೇಕು ಹೇಳಿ?
Today matter.
Huh?
Today matter.
Release tomorrow.
Yes, my lords.
Tomorrow we'll have
Tomorrow, perhaps my schedule is set that I may
Day
not.
after tomorrow, we'll have in the
No,
preliminary. hearing.
can it be had on tomorrow at least? It's okay, tomorrow, not on day after tomorrow.
Huh?
Tomorrow, my lords, may I have some personal inconvenience, my
Court has convenience.
lords. Day after tomorrow is fine, my lords.
No, I'll be out of Bangalore on professional work.
Okay, release the
Please.
matter on Monday in the same stage.
Grateful.
ಅದೇನ್ ಕೊಡಿ?
Not for writ of mandamus, directing the respondents to consider representation. Representations are at annexure A to A, annexure A to annexure E, my lords.
What is the representation?
Now, I have requested them to develop the road, my lords. ಈ ಕುಡಿಗೆಹಳ್ಳಿ ಗ್ರಾಮದಲ್ಲಿರುವ ಕೊಡಿಗೆಹಳ್ಳಿಯ ಉರುಳುಗೆರೆ ರಸ್ತೆಯ
They have
ನರಸೇಗೌಡರ
none
ಮನೆಯ
photo.
ಬಳಿ
Yes,
Yes, my lords. ರಸ್ತೆಯನ್ನು ದುರಸ್ತಿ ಮಾಡಲು ಕೋರಿ, my lords.
you want formation of road.
Yes, my lords.
So we'll dispose it of this. Huh? They have not formed a road as yet.
Not formed, my lords.
ಮಾಡಿಲ್ಲ ಅಂತ. ಅದೇನ್ ಸ್ವಲ್ಪ ವಾಯ್ಸ್ ಅವ್ರದ್ದು ಸ್ವಲ್ಪ ದಿ petitioner has sought for issuance of writ in the nature of mandamus to direct respondents to consider representation dated 12/9/2017 at annexure A, as well as this representation made to the second respondent on 12/9. Representations sought for consideration of the representation dated 12/9/2017 made to respondents 1 to 4, 1 to 5. Full stop. The representation made is to the effect that there is a road being used since many years, and such road provides access to travel between the house of Narsegowda till the house of Kemparaju, and that a neighbor, Girish, whose property lies alongside such road, has been objecting to the road works. In light of the same, the petitioner has sought for necessary direction to ensure that the road is developed and is rendered for public use. Such representations have been made as per annexures A to E. Now, who has to form the road now? Now this falls within panchayat limit.
Panchayat, my lord.
So then direction is to be made to the fifth or the fourth respondent.
Second and fourth respondent, my lord.
Second and fourth.
Yes, my lord.
In light of the limited prayer sought for regarding development of road, which is the only access as pleaded. Respondents number 2 to 4, 2 and 4. Huh? They served. They served. Anybody, is there any standing counsel for Executive Officer Taluk Panchayat? I'll dictate it, we'll call him then. I'll dictate it, we'll call him. Indian Bazar last time? Two and 4, the representation at annexure B and D to be disposed of within a period of 4 weeks from date of receipt of certified copy of the order. And once the authorities are of the view that the representation is to be disposed of in the affirmative, necessary steps to be taken as sought for in the representation as per law. Accordingly, petition is disposed of. Learned Counsel Nagarajappa is directed to accept notice for respondent number 2 and 4. 2, 4 and 5. Let him come, we'll inform him. Yes.
Here for respondent number 1.
Yes. Annexure A, they're seeking implementation of Annexure A. Just read Annexure A. Read Annexure A. Yes. So now we will find out who appears for Hassan Urban Development Authority.
I represent Hassan Urban.
Now you'll have to find out what has happened, because this is a order of the year 2012.
Please, ma'am.
So I'll have it next week in the same stage, find out.
Please. We have communicated, my lords, to the second respondent, my lords, to take action. That is at annexure A. All the communications that
annexure
A, my lords. And at annexure D, my lords. page 14.
Now, who has to take action?
It is the domain of second respondent, my lords. We have demarcated what is the violation, and the action has to be taken by second respondent. Gram Panchayat.
Instruction from the respondent number 2 is no more. Gram Panchayat has been merged with the Nagar Sabha. So there is no more respondent number 2. Instructions I have the Panchayat. I have to take a public check. What do you learn?
Merged with the town municipal. What happens to pending action then in case of it being taken over by some, it being upgraded? What happens to that? You just make a submission next week. In law, what happens to pending action? So if in that notification, you get the notification and see, if it is so, then we'll direct that other authority to be made a party, or say that the same order is further steps are to be taken.
Fourth respondent is also necessary party, my lords. They are impleaded now. I don't think he is served.
Correct, but now petitioner needs to take steps.
Please, first.
No representation on behalf of the petitioner. It's made clear that if the petitioner remains absent on the next date, noticing the matters of the year 2018, necessary, court would be constrained to pass adverse orders. List the matter on. When do you want? Relist the matter on. Date coding. Correct. So in law, what happens? No? And so they'll have to take action. He'll have to implead them and they will have to take action, examine it. You appear for? Now, which is that new authority? Town Municipal CMC? Hassan. You appear for the CMC Hassan also, is it?
Please, my senior appears, Mr. Ravi Shankar.
Now, the Council for Artus submits that CMC Hassan has taken, I mean, this Panchayat has now merged with CMC Hassan. So we'll let the petitioner come. You also find out. Now,
Please.
in light of that, what is to be done, you find out. Get instructions.
Please.
Relist the matter on 29th.
Much obliged.
Serial number 9, urgent. Serial number 10, Ajit PB.
Appearing for the petitioner, writ of mandamus, Your Lordship.
Yes, BBMP.
Report is already submitted on last date. Further, what action has been taken, I will take instructions and my submission.
Here, now this construction is by whom?
Worship, the respondent 1.
Respondent number 1.
Please.
Both petitioners and respondents' property were surveyed, and in
What
both
is the
properties there is illegal construction, so deviations are there.
R1.
Oh, yes, my lordship. Petitioner's properties report is at page 2 of my survey report, my lordship, which was filed on 16th November.
Your Lordship, with respect to petitioner's report, there is a remark that unauthorized ground floor and first floor constructed. For that, conversion sanction certificate has been obtained, Your Lordship, from it's an old building, it's obtained from HASB. I would like to place it on record in by filing memo to that extent.
Now, forget about him. Now, it's up to you to take action against him. Now, he's complaining against the first
Respondent.
respondent.
Page number 3, my lordship. That is
Page
3, next page. That shows the deviation done by respondents, my lordship. There are setback violations.
So then you take action in terms of the field inspection report and we'll close. The petitioner has sought for issuance of direction to respondents to consider the representations made by the petitioner to ensure E to L and has further sought for direction to take action in terms of section 248 of the BBMP Act 2020. Full stop. During the pendency of the present proceedings, this court by an interim direction had ordered for a spot inspection and pursuant to such a inspection, report is filed on 16/11/2023 by the respondent BBMP. Admittedly, in terms of the field inspection report, the first respondent in his construction is stated to have deviated from the sanction plan and not left setback. Full stop. If that were to be so, respondent BBMP is to take further action as per law in terms of section 248. Needless to state, necessary adherence to principles of natural justice will have to be adhered to. Full stop. Though the field inspection report also points out to certain deviations by the petitioner. As regards such deviation, counsel for the petitioner submits that sanction has been obtained
From HA sanitary board memo. Copy of it.
Sanction has been obtained from the competent authority in the year 1967 itself, and the same has been, and the said deviation has been regularized. Full stop. Memo is filed, enclosing copy with certain documents. However, further, counsel for the petitioner submits that if regularization has been made in the year 1967, authorities cannot take action after an unreasonable period of time. Needless to state, the petition has been filed insofar as the illegal construction of the first respondent and confining the petition to such prayer in light of the direction made above to the respondent BBMP to take action under section 248 as per law. Petition is disposed of.
Your lordship, a time frame maybe.
No question, no case arises for adjudication as regards the lapse, as regards the deviation, if any, of the petitioner in the present petition. Yes.
Your lordship, a time frame maybe.
They will take action.
Serial number 11 urgent, serial number 12 Subbareddy KN.
Kindly pass on the matter. Senior respondent, kindly pass on matter pertaining to cancellation of Kata by the respondent PDO. that we have encroached certain portion of the school property. The complaint was instituted by respondent number 3 and 4 for the PDO. There is an order
Kindly
of civil
pass
court,
out.
my lords, for an order.
Let's see, let him come, pass over.
Notices are yet to be issued, my lords.
Notice?
Notices are not being issued.
Could you? Notice to whom?
Notice to the respondent number 1 and 2. 3 and 4 are appearing to caveat.
4 and 5 caveat.
4 and 5, my lords. 1, 2, 3 notices not to be.
Now you appear for 3
4 and 5.
4 and 5. Yes. Now, Executive Officer, Taluk Panchayat, Sidilgatta, Chikbalapura. You appear. Just show him the cost title. To which all respondents you will take notice.
1 and 2.
2 and 3.
2 and 3. 2 and 3, sorry.
2 and 3.
Land Council MS Devraj accepts notice for respondent 2 and 3. The list state is, you have accepted. AGA is directed to accept notice for the first respondent. List the matter week after next. Petitioner is permitted to correct the description of the second respondent.
Let them not precipitate the matter because they are pursuing to demolish a property in view of the cancellation of Pata. There is in fact an order of the civil court also that not to interfere with the petitioner's possession. I'm just praying before your lordship that let them not take any precipitatory action. R2 and 3 may be directed not to take any precipitatory action.
Well, let us see, we'll have it on Monday. You make preliminary submissions. We'll have it on Monday. Relist the matter on Monday. On Wednesday.
Tell them, my lords, at least let them be directed not to take.
No, let us see, let us see. It's school property, so let us see. Correct the description of the second respondent. What is the mistake? Yes.
Serial number 13, Bhargav G.
You correct it now itself.
Here for petitioner.
Good.
Serial number 13, Bhargav G.
Kindly place time. Senior infant.
What is the matter?
ನಾಳೆಗೆ ಹಾಕಿ
ಇದ್ರಲ್ಲಿ ನೋಟಿಸ್ ಆಗಿದೆ. Let us see, we'll order notice and then have it on a different date.
preliminary hearing ಮಾಡೋದು. preliminary hearings ಇದೆ. ಸೀನಿಯರ್ಸ್ ನಾಳೆ ಬರ್ತಾರೆ ಅನ್ಸುತ್ತೆ. ಇವತ್ತು ಸ್ವಲ್ಪ ಕನ್ವೀನಿಯನ್ಸ್ ಇರೋದ್ರಿಂದ ಬರಕ್ಕಾಗಿಲ್ಲ. ದಯವಿಟ್ಟು ನಾಳೆಗೆ ಹಾಕಿ.
We'll list the matter. No, let notice. We'll direct the authorities to take notice and we'll have it next week. I'll fix a date. PG accepts notice for the first respondent. Zilla Panchayat Tumkur. Land Council A. Nagarajappa is directed to accept notice for the second respondent. Then Assistant Executive Engineer Hemavati, Kaveri Neeravari Nigam. Yaru idhar standing council. Case BMI is directed to accept notice for the third respondent. Third and fourth respondent. Emergent notice to the fifth respondent. Relist the matter in the orders list on date 29th. Meanwhile, serve copies. Let us see. 29th. You serve copies on the standing council. Yes.
Serial number 14, Sachindra Karan.
They appear for the
R7.
The fourth respondent has filed their objection, served it on me on the 11th. I'll have to file my reply to that. While your lordship will recollect, on the last occasion, they said they are not widening the road.
No, who's it?
Milord, I appear for this one number 4
Yes.
for NHI, and we
Yes.
have filed statement of objection stating that we are not working on this road, Milord.
While they've done that, they have deposited the amount with the electricity board to shift the poles. Because I'll file my rejoinder with the.
No, let us see if they're saying that they are not
That, what they say is, the road has not been handed over to them.
So who, has it been acquired?
It's not been acquired. That's my grievance. The direction I've sought is acquire the land and widen the road. Pay me the compensation. That's the relief I've sought, your lordship.
Now the property along, this are
all private properties.
It's a national highway.
It's not. National highway is 8 kilometers to the south. It's come into a property which belongs to a politician. So they've diverted it. Now they want to take it through Gauri Bidnur town. Well, if your lordship will take the last of the petitions I filed. 01
601
25601. Well, it's page 56, annexure K.
Page 56.
These are the photographs of where the national highway ends. 56 and 57.
Yes.
This is the national highway which has been constructed about 8 kilometers to the south of Gauri Bidnur town. Your lordship will find that in the Google map I have produced.
Now, if at all,
yes,
the road is to be done, it has to be done by the National Highway Authority.
Yes.
Because it's for the purpose of National Highway. If at all.
It's not notified.
No, correct.
Yes.
So if at all, it has to be extended.
Yes.
It has to be done only by the NHAI.
Yes.
Now, if the NHAI states that they have not acquired it, we'll record it and then say that you will not touch it unless property is acquired in accordance with law.
They do not even say that it's not acquired.
So that will
That
see.
it's acquired, yes.
Now,
Milord, yes, Milord.
if
May
it is, yes.
May I clarify, Milord? Milord, as per Milord, Section 5 of National Highways Act, responsibility for development and maintenance of national highway, so they may give it to state government or to National Highway Authority of India. So certain national highways in state of Karnataka are being taken care or maintained, developed by state government under PWD.
Section?
And certain national highways
Section?
are Section 5, Milord, of National Highways Act.
Yes.
Yes, Milord.
Yes.
It shall be the responsibility of the central government to develop and maintain in proper repair all national highways, but the central government may, by notification in the official gazette, direct that any function in relation to the development or maintenance of any national highway shall subject to such conditions, if any, as may be specified in the notification, also be exercisable by the government of the state within which the national highway is situated, or by any officer or authority subordinate to the central government or to the state government. So
Now this highway in question, what is the position?
Milord, as per Milord, my instruction, this has not been entrusted to National Highway Authority of India. So we are not doing any work so far as the location which is in question.
No, so the central government may have to be implemented.
Milord, state government, Milord, may be verified whether if they are doing any work. But we have instruction that we are not doing any work on that, and that stretch is not with NHA.
Yes, who appears for seventh respondent? So what is your instruction? You will have to take a stand now. If it's a highway, in terms of Section 5, whether you have entrusted it to the state government or the NHAI, you will have to take by the next date.
Next date.
The Learned Council for NHAI submits that the development of the national highway in question has not been entrusted to NHAI and draws attention to Section 5 of the National Highways Act 1956. Full stop. Perusal of Section 5 of the Act would indicate that it is for the central government to entrust the development or maintenance of national highway either to the government of the state or any authority subordinate to the central government or state government. In light of the same, the central government to take a specific stand as to whether the development and development of the national highway in question has been entrusted to the state government or any other authority. Relist the matter on after 10 days, one date.
After 2 weeks, my lord.
31st.
Date could be.
Well, can I request your lordship to look at annexure H, my lord? The
Annexure?
fourth respondent may need to make a statement in respect of that. Annexure H. This is the engineering sketch.
Page.
Page 50, my lord.
Yes.
Annexure H.
Yes.
This is an engineer sketch given to the contractor to widen the road. And this passes through the very same road on which we are.
No, so let the central government take their stand, then it will become.
Then we will.
Yes.
Milord, we have not been, Milord,
Let us see.
in the copy of, yes, Milord, in the copy of petition served upon us, that annexure is missing, Milord.
WP 25601 of 23. At annexure H in that writ petition, last at page.
All the petitions have this annexure.
Let us see. Yes, please. Now you central government, you better take a stand by the next day. Yes.
Date 31st.
Milord, may I just submit? Milord, if we look at that in one petition, I found that sketch. It is mentioned National Highway PWD, Milord. So it is clear, Milord.
Which
Milord, that annexure which my learned friend was showing. Milord, there is one, it's a National Highway PWD. Annexure GH. Milord, at just bottom, Milord.
Yes.
It's a just say National Highway PWD. Your lordship found it?
So it has been entrusted to the state according to
Yes,
you.
Milord. Yes, Milord.
Then, okay, I order better. Now you take. No, then I'll record that. That's all he's bothered. Yes. So we'll record that undertaking of the state.
But without acquiring it in
Acquiring, they will not pass. Yes. Yes.
What they've been doing is in Gauribidnur and Kolar, they have threatened them. If you concede 20 feet, we will not take 40 feet of your property. If you concede, we will make it 20 feet. Anyway, it will only 20 feet which is to be acquired.
That is strategic bargaining.
Correct.
The petitioner. So common order we can pass.
Yes.
The petitioners in these petitions have sought for issuance of writ of mandamus to direct respondents not to demolish any portion of the scheduled properties belonging to the petitioners as described in each of the petitions, and have sought for an order of restraint against the respondents not to take any action without following due process of law by resorting to acquisition. As the relief sought for and the factual matrix in all the petitions are identical, all the petitions are taken up for disposal and are being disposed by a common order. It is the case of the petitioners that they are lawful owners of the properties, details of which have been furnished in the petition, and that there have been survey regarding formation of road. It is submitted that the proposed national highway number 69.
Yes.
Number 69 is being laid out. And in the context of laying out such road, there is an apprehension to the petitioners regarding encroachment of their properties. Full stop. Petitioner submits that without any acquisition having been conducted, there is a threat of utilization of the petitioner's property. Reliance is placed on the sketch, on the survey sketch, in which it is submitted that the highway runs through properties of the petitioners.
Yes.
Full stop. Third council appearing for the NHAI submits that the development of the national highway, which is the subject matter of the present petition, has not been entrusted as yet by the central government, and accordingly, unless there is entrustment under section 5 of the act, question of the National Highway Authority executing any work does not arise. And further points out that the sketch enclosed along with the writ petition 25601 of 2023 at annexure H would indicate that the development of the highway has been entrusted to the National Highway within bracket PWD, close bracket. Third AGA submits that upon instructions that though the formation of the highway is a task entrusted to the state government, however, it is clear that they would not make use of any private property without resorting to acquisition as per law. In light of the said undertaking, petitions are disposed of taking note of the same, while observing that there cannot be utilization of private properties of the petitioners except after acquisition or obtaining transfer of title by negotiation as per law. Such direction would take care of the grievance of the petitioner and apprehension regarding violation of right under Article 300A. Accordingly, petitions are disposed of.
Serial number 15, Hemant Kumar GM.
Pay for the petitioner, my lord.
Yes.
Of mandamus, my lord. Illegal reconstruction on the old building in additional 5th and 6th floor, my lord. Copies is furnished.
Pawan Kumar.
This matter, as per my instruction, even 248(1)(2)(3) confirmation order is also passed. Even we have started some demolition also as per my instruction. Finally, I have it is Friday or Monday. I will place it on it.
We'll have it on Monday.
Yes.
Relist the matter Monday in the same stage.
Serial number 16.
This appear, my lord, for the petitioner. My lord, annexure A, my lord, we sought for change of kata. My lord, respondent number 5 was served, my lord, his name is not shown in the cost list, he might be. We have served them, my lord, and filed a memo before this court. In the cause list today, my lord, his name is not shown. Respondent number 5.
Who appears?
So Narayan Swami, my lord, advocate, we have served on him. Yes, Narayan Swami.
Learned counsel. So we'll show his name and then we'll fix a date. Let us see. What is the main relief?
My lord, we have sought for change of kata. Now, annexure A, my lord, the BBMP says in view of the RFA pending, kata cannot be changed. My lord, there is no interim.
To show the name of learned counsel Shri K.S. Narayan Swami as representing respondent.
Number 5.
Respondent number 5. Relist the matter on
25th. 25th.
25th in the same stage.
Obliged.
Serial number 17, GS Prasanna Kumar.
It's annexure B, my lords, at page 14.
I had sought for sanction plan, my lords.
As per my instruction, what has happened here is some conversion they have not obtained. So we have sent the file for legal opinion to the legal cell. Concerned officer has sent it. Kindly have it week after next. We will get that opinion by that time. If something is there, we will file our objections. And then we can
My lords would appreciate the property comes within the limits of the BBMP. Question of even obtaining conversion doesn't arise at all.
That's a legal
Latest
opinion.
judgment of this honorable court is very clear on that issue. And they are making this matter alive for more than 1.5 years, my lords. Huge investments and there is escalation in the price. All this is going to have the effect on the building, my lords. For more than 1 year, my lords. 26 November 2022, this application was submitted, my lords, at annexure 4.
Correct. Now, if the judgment is in force, which is referring to, then you will have to take note of it and you'll have to dispose it of.
Let him give a copy to. I will just place it before the legal cell.
Judgments are also there. Latest judgment on 3rd January 2023.
Because the concerned officer, the town planning section has sent the file for legal opinion because of all these questions. If he gives me the copy of the judgment, I will place it before the legal cell so they can take an action.
With that direction itself, my lords, this matter may be disposed of. Within 15 days, let them take the decision on this application.
Otherwise, they will file contempt and everything. Kindly have it week after next by that time.
There's a new tendency, my lords, to give the sanction plan. They are making unnecessary delays and subjecting the petitioners to come up with different.
No, now you have a look at this. If it's the point is answered, same point is answered.
Please.
Then you take your call.
And have it at least next week, my lordship.
Relist the matter in the same stage on
23rd.
23rd.
24th.
24th. Now, whether we like it or not, if the point has been answered, there ends the matter.
Yes.
Serial number 18, Srinivas V.
Respondent in this matter, my lords.
Petitioner in this case.
So this
But
matter
in
has
this case, I challenge the demand notice and the show cause notice where I made a submission that show cause notice was not served upon me, my lord. Now, my lord, by virtue of the demand notice, my lord, every day in and day out, I am facing the trouble, my lord. Every day officers are coming to my doorsteps. Now, my lord, in the meantime, my lord, I have not, my lord, show cause notice here, we have not given, my lord, show cause notice was not at all served upon me. Now, my lord, if I am permitted to file a reply to the show cause notice and if this demand notice goes, my lord, I can respond to the show cause notice at least, my lord. I can respond to the show cause notice.
My lordship have asked for original records. The person is coming. It can be passed over. He can also see whether it is served or not. As per my instructions.
Pass over, you share it. Now he is saying that it is not served upon him, and if that were to be so, reopen the proceedings. He'll file his reply within a time limit, and we can dispose it. You satisfy yourself whether there has been service or not. Pass over.
His name, B.S. Karthikeyan appears for BBMP.
Examine.
Please.
Pass over.
May I request this matter be listed tomorrow, my lords?
Tomorrow.
Yes.
Meanwhile, have a look at the
I'll share the
records.
documents with you.
Have a look at the records. We'll have it tomorrow. Relist the matter tomorrow in the same stage.
Great.
Orders matter, serial number 19, Prasanna Kumar P. Serial number 19, Prasanna Kumar P.
For the petitioner, my lord.
Yes.
Lordship, this matter has become infructuous, my lord.
File a memo.
Memo is.
Now, what is the, you want to withdraw it?
Please.
Anyway, lordship, matter will become infructuous. The allegation in the writ petition issue, they have filed a false affidavit before the returning officer. The election pertained to 2010 of the Bengaluru Municipal Corporation election. Now, lordship, there is no consequences.
Now, you appeared in the
Contesting respond number 4.
Some matter last week.
Same matter, lordship. That is the matter.
Huh?
That is the matter.
No, one more matter we have disposed of, stating that the penalty of removal of membership is only in the term of.
That is not this case. That is different case.
Anyhow, they want to withdraw it. We leave it at. Counsel for the petitioner has filed a memo which reads as hereunder. It is submitted that since the term of office has expired, question of continuing with the present proceedings does not arise. In light of the memo filed, petition is dismissed as having become infructuous. Now order of removal was passed, which you have
No, no, no,
challenged.
not removal. Your Worship.
Ah.
They filed an application before the returning officer saying that they filed a false affidavit, take action accordance with law.
That was dismissed.
That is dismissed. Now that order is challenged before this honorable.
Serial number 20.
There's one point, just one. Under section 12H of the Gram Panchayat, this is not to this case. 12H of the Gram Panchayat, question of disqualification. If you have done work relating to the Gram Panchayat or entered into a contract relating to employment or supply of goods or services. So the contention raised is that the plain language of 12H points out to if you have done work before, you are automatically disqualified. To the contrary, the argument is the disqualification must relate to a subsisting contract or something during the term of office.
Correct.
If there's any judgment on the point,
I will share it.
Yes.
Serial number 20.
Sir, the petitioner herein, my lord, is an auction purchaser of a corner site bearing number 1262. Now, when the auction, my lord, was taken, my lord, the price had been fixed. I was the highest bidder. The price that was fixed, my lord, was per square meter 3068, my lord, was the price that was fixed. My lord, as per which, my lord, they had executed a sale deed in my favor.
Sale deed is executed.
Sale deed is executed in my favor. My lord, with a specific boundaries, my lord, that have been mentioned. So my first respectful submission, my lord, is all those part and parcel of the property well within the boundaries that were mentioned in the sale deed had been conveyed in my favor. And the price had also been fixed, my lord, as I mentioned, at the rate of 3000 rupees, 3068 per square meter. Thereafter, my lord, it appeared that there was 83 square meters of land, my lord, which was present well within the boundaries. And the measurement, my lord, was not shown. In my sale deed, my lord, the measurement that is shown is 456.25 square meters.
Now take me to your sale deed.
Please, my lord. My sale deed, my lord, is at Annexure B. And the schedule, my lord, is at page number 16.
Two four six two,
my lord, please.
456.
456.25 square meters of the land, my lord. And the boundaries, my lord, are specifically mentioned. Purvake 2461, Paschimake raste, Uttarake raste, Dakshinake so on.
Yes.
Now what happens is, my lord, may kindly take the sketch, my lord, that is there at page number 21.
Sketch at?
My lord, sketch appended to Annexure D. It is at page number 21, my lord. Page number 21. Now, my lord, what has been darkened there, my lord, is the measurement, my lord, did not include this 83.75 square meters of land. Now, I am required to pay, my lord, for the said amount, said land, which measures 83.75 square meters at the rate, my lord, that was initially agreed upon. So I make a representation to the respondent and seek, my lord, for conveyance of that portion of the property also at that rate. Now the endorsement, my lord, at Annexure D, which is subject matter of the challenge is, my lord, I was called upon to pay a sum of rupees 28,97,917 rupees, which, my lord, comes down to for 83.75 square meters of land. As against, my lord, what I have purchased 456 square meters of land at the rate of 3,000, my lord, I have paid 14 lakhs. Now they called upon me to pay this amount. My lord, under protest, I have paid that amount and they have already executed a sale deed in my favor concerning 83.75 square meters of land also. My lord, I have been making a representation, my lord, throughout, saying that I have paid the excess amount. I'm not satisfied with the calculation. And hence, my lord, the challenge that has been laid here is the earlier amount, my lord, that have been fixed as per Annexure A, where the auction took place, is the amount that binds us. Now, if there is any variation in the measurement that have taken place, I can't be called upon to pay the existing market value because this all dates back to the original auction. That is, my lord, the contention that I have raised.
Yes.
That's what is questioned, my lord, is the endorsement is at Annexure D, page 20, my lord. But this endorsement relating to allotment of the bit of land, marginal land. But pursuant to this communication of allotment, but he has paid the entire amount, and the absolute sale deed is also executed for the difference of the 83.97 square meters. But after obtaining the sale deed and after constructing the commercial building portion of the plot for commercial purposes, but this petition is filed. My respectful submission is not.
What is the time lag?
The time lag between the original auction and the subsequent sale transaction also to be taken note of. The original auction sale was held in 2005. But this marginal plot was allotted in 2015, and the writ petition is filed in 2016. And kindly see the plan which has been sanctioned by the Mysore City Corporation for construction. I have produced along with a memo. The boundary will prevail over the extent of the property doesn't apply for the present concern. That analogy could be applied in a suit for injunction for the trial court. But here is a case where a largesse of the state is being conveyed to a private individual, but the prevailing auction price, which was prevailing as on the date of allotment of the marginal plot. When he has accepted the demand and paid the money, afterwards, after obtaining the sale deed, he can't turn back and say the fixation of the consideration is wrong. If he was aggrieved by the fixation of the price, it was open for him to challenge it at then and there itself. But after getting the sale deed and after obtaining the building plan and license for 540 square meters, as against the original allotted plot of 456 square meters, that he can't challenge the action of the authority in fixing the price.
Now, when did you call upon him to pay this?
Please, notes. The Annexure D itself is the demand notice.
Now the
this acted Annexure D.
Sale deed is dated?
That sale deed is dated.
of April 2005.
15/3/2016.
Sale deed.
5th March 2016. Sale deed in respect of this marginal plot.
No, the sale deed of the first auction.
First auction. That is of 2004. So 2005.
15/4/2005.
2005. Annexure D.
2005.
Please, ma'am.
Now, when was this excess realized?
That the petitioner himself made a request that I am ready to purchase the excess land and allot me this land and execute the sale deed.
Now, this sale deed dated 15/4/2005, have you produced?
Yes, my lord, I have produced.
Annexure.
That is what, my lord, I brought to my lord's notice at Annexure D.
Initially, it was not produced. Along with the rejoinder statement, my lord, it was produced at page 10, my lord, of the rejoinder.
The first sale deed has been produced at Annexure B. The second sale deed, my lord, along with my rejoinder as Annexure L, I have produced it.
The first sale deed.
Yes, my lord, it is at Annexure B, my lord, page number 10.
This is dated 15th of
April 2005, my lord.
Okay. When did you make the representation for this excess land?
My lord, I made this representation, my lord, as per Annexure C. It is in the year 2015, my lord.
2015.
Please, my lord.
Just read Annexure C.
Please, my lord. Page number 19, my lord, typed copy I have produced. May I read, my page number 19?
Yes.
ನಾನು ಈ ಮೇಲ್ಕಂಡ ನಿವೇಶನವನ್ನು 9/7/2004 ತಮ್ಮ ಕಚೇರಿಯಲ್ಲಿ ನಡೆದ ಅಧಿಕೃತ ಹರಾಜು ಪ್ರಕ್ರಿಯೆಯಲ್ಲಿ ಪಡೆದು ಈ ನಿವೇಶನದ ಕ್ರಯಪತ್ರ 15/4/2005 ಪಡೆದಿರುತ್ತೇನೆ. ಈ ಮೂಲೆ ನಿವೇಶನಕ್ಕೆ ಹೊಂದಿಕೊಂಡಿರುವ ಪೂರ್ವ ಪಶ್ಚಿಮದಲ್ಲಿ ಅಂದಾಜು 2.5 ಮೀಟರ್ ಇಂಟು 1.5 ಮೀಟರ್ ಪೂರ್ವ ಪಶ್ಚಿಮದಲ್ಲಿ ಹೆಚ್ಚುವರಿ ಜಾಗ ಕಂಡು ಬಂದಿರುತ್ತದೆ. ನನ್ನ ನಿವೇಶನದ ಚಕ್ಕುಬಂದಿಯಲ್ಲಿ ಪೂರ್ವಕ್ಕೆ ನಿವೇಶನ ಸಂಖ್ಯೆ 2461 ತೋರಿಸಿದ್ದು, ಪಶ್ಚಿಮ ಹಾಗೂ ಉತ್ತರಕ್ಕೆ ರಸ್ತೆ ಇದ್ದು, ದಕ್ಷಿಣದಲ್ಲಿ ಸಂಖ್ಯೆ 2163 ಹಾಗೂ 2464 ತೋರಿಸಿರುತ್ತದೆ. ಹಾಗಾಗಿ ನನ್ನ ನಿವೇಶನಕ್ಕೆ ಸೇರಬೇಕಾದ ಹೆಚ್ಚುವರಿ ಜಾಗ 9/7/2004 ಹರಾಜು ಪ್ರಕ್ರಿಯೆಯಲ್ಲಿ ಬಿಟ್ಟು ಹೋಗಿರಬಹುದಾದ ಶಂಕೆ ಇದ್ದು, ಈ ಲೋಪವನ್ನು ದಯವಿಟ್ಟು ಸರಿಪಡಿಸಿ ನನಗೆ ಮಂಜೂರಾತಿ ಮಾಡಿಕೊಡಬೇಕಾಗಿ ಕೋರಿರುತ್ತೇನೆ. ಈ ಪತ್ರದಿಂದ ಅವಶ್ಯಕ ದಾಖಲಾತಿಗಳನ್ನು ಒದಗಿಸಿರುತ್ತೇನೆ. ನಾನು ಹರಾಜಿನ ಶೀಟನ್ನು ಕೊಡಲು ಸಿದ್ಧನಾಗಿದ್ದೇನೆ. What I have specifically said, my lord, is you have conveyed it to me, but the measurement concerning this extra portion of land which comes well within the property that has already been sold in my favor seems to have been missed out, and I am ready to pay the amount for that extent is what I have stated.
Correct, but what was conveyed was only excluding this portion.
Yes, my lord, but well within the boundaries. That is where I am saying, my lord, we are bound by the original contract.
Correct, but under the bid, it is as per square feet, isn't it?
As per square meters, my lord. That is where I am saying.
Annexure A, my lord, ask them confirmation letter.
Annexure A, my lord, will kindly see page number 8, serial number 2. What had been agreed upon is ಪ್ರತಿ ಚದರ ಮೀಟರ್ಗೆ 3068 ರೂಪಾಯಿಗಳಂತೆ ನಿವೇಶನದ ಒಟ್ಟು ಬೆಲೆ ಅಂತ ಮಾಡಿದ್ರು. Now all that, my lord, the measurements which comes well within that site which was already sold will have to carry this price, because this is what, my lord, I bid.
What is your explanation as to how this was left out? This portion.
At that point of time, what transpired, my lord, record doesn't disclose that it is a corner site which has been auctioned. In fact, it should have been included, my lord, or else if the marginal plot is in between two sites, it should have been shared between two, my lord, owners. However, my lord, it has been granted to the petitioner himself. My lord, he has put up, kindly see, my lord, the construction put up by, along with the memo, my lord, I have produced, memo dated 8/9/2023. The sanction of building plan is in respect of 540 square meters, inclusive of this 83.97 square meters. And kindly see page number 4 onwards.
And this he must have noticed at the time of sanction
plan. Therefore, he has approached the authority. And he got the benefit of the allotment and put up huge construction. Now at this junction, it would not be within his competence to seek for refund of the amount which is paid under a registered sale deed.
Series of representations, my lord, that I have produced along with the rejoinder.
When is the second sale deed executed?
5th of March 2016, my lord.
5th of March
2016.
It is along with my rejoinder, my lord, at annexure L.
It appears, my lord, after obtaining the sale deed, the writ petition is filed. The date of filing of the writ petition is not indicated here, my lord. In all probability.
Yes. Sale deed ಆದ್ಮೇಲೆ ಹಾಗೆ.
If he was aggrieved by the fixation, my lord, it was open for him to challenge annexure D at that point of time.
The petitioner.
I just point out certain representations that I have made. My lord, all these things have done under protest. Now it is not that, my lord, I took it and thereafter as an afterthought I have done this. May I request, my lord, to kindly take my rejoinder.
Now the only point is.
Yes, my lord.
That admittedly the first sale deed was excluding this deficit of
83 square meters of land.
83.75 square meters.
Please.
So now you yourself have sought for clarify or conveyance of rectification of that by a fresh sale deed.
Please, my lord. No, what I said is, my lord, it is part and parcel of my property, and by mistake it has not been mentioned.
That was not a mistake, because what was conveyed by the sale deed, irrespective of the boundary, was only X extent, and the price that was fixed was calculated on the basis of what was conveyed. And in terms of 3068 into the extent that was sought to be conveyed in the sale deed.
456 square meters.
So the price was fixed.
Yes,
so with respect to the remaining portion, if you are to get the benefit, then you have to pay it as on the date the sale deed was executed.
No, one submission, my lord, on the statutory principle. Now, my lord, when the Karnataka Urban Development Authorities disposal of corner sites and commercial sites rules of 1991, especially, my lord, Rule 5 reads as under, my lord. amalgamation of corner site with the adjacent site, where the width of a corner site is not more than half of the width of the adjacent site. Such corner site shall be amalgamated with the adjacent site, and such amalgamated site shall be deemed to be the corner site. So what was available was the entire corner site which was put under auction. And what they, my lord, when they were conveying, only the measurement have been, my lord, shown on a lesser side. Now it was one compact commercial corner site, my lord, which was available for allotment.
There is no doubt about that, but the fact remains that what was conveyed was lesser than the entirety of the site.
Well, certainly,
and the price that was paid
please,
is not for the 83.75.
Yes, my lord. That is where I made a mention that, my lord, at the rate of 3,068 square meters per square meter, I'll pay for that 83 square meters of land also. Because that is what
Maximization of state interest.
My lord, ultimately not at my cost, my lord. Now this is
Beneficiary is the beneficiary.
Let us, the petitioner has sought for issuance of writ of certiorari to quash the endorsement at Annexure D. In terms of the endorsement, just read Annexure D.
ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ನಿಮಗೆ ವಿಜಯನಗರ 2ನೇ ಹಂತ ಬಡಾವಣೆ ನಿವೇಶನ ಸಂಖ್ಯೆ 2462ಕ್ಕೆ ಹೊಂದಿಕೊಂಡಂತಿರುವ ತುಂಡು ಜಾಗವನ್ನು ಮಂಜೂರು ಮಾಡುವಂತೆ ಕೋರಿ ಉಲ್ಲೇಖ 1ರ ರೀತಿಯ ಸಲ್ಲಿಸಿದ್ದ ನಿಮ್ಮ ಅರ್ಜಿಯನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿದೆ. ಉಲ್ಲೇಖ 2ರ ತಾಂತ್ರಿಕ ಶಾಖೆಯ ವರದಿಯಂತೆ ಸದರಿ ನಿವೇಶನಕ್ಕೆ ಸೇರಿದಂತೆ ಲಭ್ಯವಿರುವ ತುಂಡು ಜಾಗದ ಅಳತೆ ಒಟ್ಟು 83.75 ಚದರ ಮೀಟರ್ಗಳು ಲಭ್ಯವಿದ್ದು, ಈ ತುಂಡು ಜಾಗವನ್ನು ಮಂಜೂರು ಮಾಡುವಂತೆ ಉಲ್ಲೇಖ 3ರ ಆದೇಶದಂತೆ ಉಲ್ಲೇಖ 4ರ ಪ್ರಾಧಿಕಾರದ ನಿರ್ಣಯದಂತೆ ಆದೇಶವಾಗಿರುವುದರಿಂದ ಸದರಿ ತುಂಡು ಜಾಗದ ಬಾಬ್ತು ರೂ 28,97,917 ಗಳನ್ನು ನಿಗದಿಪಡಿಸಿದೆ.
In terms of the said endorsement, the respondent, number
sole
respondent
4.
Sole respondent.
So the respondent has called upon the petitioner to pay an amount of 28,97,917 as regards to the extent of 83.75 square meters, which extent was left out while executing the sale deed at Annexure B, whereby extent that was conveyed to the petitioner by execution of sale deed consequent to the auction proceedings relating to the corner site was an extent of 456.25 square meters. Such endorsement has been passed pursuant to the request of the petitioner himself at Annexure C, dated
the date, my lord,
at Annexure C.
4/2/2015.
Where do you get that?
No, I don't get it there, but it has been referred, my lord, in Annexure D, reference number 1.
It's 2/4/2015. The copy is available in the original file.
The request of the file, that request of the petitioner made on
2/4/2015.
2015. Same Annexure C.
Yes.
In terms of the said representation, the petitioner has requested the respondent that while executing the sale deed, an extent of land available within the boundaries as mentioned in the sale deed appears to have been left out, and accordingly same requires to be granted. It's specifically stated in the said representation that an extent of 2.5 square meters in 2.5 by divided by 2 into 1.5.
Please, ma'am.
square meters had been left out. And as regards such extent of land which was left out, the request was made to the authority to convey the same to the petitioner. We'll stop next. The admitted facts being the petitioner has taken part in the auction of site number 2462.
Yes, please, ma'am.
In Vijayanagar second stage layout formed by the respondent and has been successful in the said bid proceedings, as is evident from the certificate, from the confirmation of auction certificate at annexure A. Full stop. In terms of the same, the rate that was fixed was 3068 per square meter, and the extent is also mentioned, which would amount to
456.25 square meters.
456.25 square meters. Full stop. Such aspect is not in dispute. Full stop. Next. Sale deed is also executed on 15th of April 2005. A perusal of the schedule in the said sale deed would indicate what has been conveyed is 456.25 square meters. And if read in conjunction with annexure A, the extent that is calculated was on the basis of rate fixed at 3068 per square meter. Full stop. Admittedly, the sale deed having been executed in the year 2005, the petitioner's request for conveyance of the extra land available within the boundary of 83.75 square meter was made only on 2/4/2015. Full stop. It is to be noticed that the amount for the said 83.75 square meters was paid on
On 4/2/2016.
On 4/2/2016. And a sale deed for such extent having been executed on
5/3/2016.
5/3/2016. The only point of dispute between the petitioner and the respondent is that the petitioner is entitled for the conveyance of 83.75 square meters at the rate at which auction proceedings were finalized, that is at 3068 square meters
per square meter.
Full stop. Learned counsel for the petitioner would contend that if the boundaries of the sale deed at annexure B are perused, the deficit of 83.75 square meter also having been included within the boundary, it appears that the respondent authority had calculated the extent with shortfall by oversight. And if that were to be so, what was intended to be conveyed was the entirety of land within the boundary at annexure B, and the deficit ought to be regularized by making appropriate correction in the conveyance deed by charging the petitioner at the rate of 3068 rupees per square meter. Learned counsel for the respondent Muda would however point out that the sale deed at annexure B was in the year 2005, while the request made by the petitioner after noticing that there was a deficit of extent mentioned in the sale deed of 83.75 square meter was by way of representation on
2/4/2015.
2/4/2015. And it is on the basis of such representation by the petitioner that the endorsement at annexure D came to be passed on 19/10/2015. It is pointed out that the petitioner has obtained a sanction plan on
This year 2016 minutes.
Where do you get that?
That's along with the memo, my lord, I have produced the copy of the building plan and license.
The plan.
I'm sorry, my lord, it is dated 9/6/2016. 9/6/2016.
In the year. On 9/6/2016, and it appears that at the time of obtaining the sanction plan, this deficit in measurement having been noticed, the representation was made as per annexure C, and that the only way of ensuring that the interest of the public entity of a state of a entity which is state for Article 12 is protected is to ensure that the price that is fixed ought to be commensurate to the prevailing price as on the date of execution of sale deed for the extent of 83.75 square meters, that is as on 5th of March 2016. Full stop. Heard both sides. It is not in dispute that in the confirmation of auction proceedings at annexure A, price that was fixed was at the rate of 3068 square meters per square meter. Full stop. The extent that is conveyed in terms of the sale deed at annexure B is only an extent of 456.25 square meter. In terms of the price fixed per square meter, as is evidenced from annexure A, the allotment price has been paid by the petitioner and sale deed executed. No doubt, an extent of 83.75 square meter in excess appears to be land available within the boundaries of the sale deed at annexure B. However, when the petitioner himself realized that what was paid for was only with respect to the extent of
56.25 square.
456.25 square meter, the representation came to be made at annexure C in the year on 2/4/2015. Full stop. There is a gap of
10 years.
11 years.
7 years.
11 years from the execution of the sale deed in 2005 to the representation at annexure C. Full stop. In case of full stop, there is no ambiguity with respect to the extent conveyed at annexure B. Admittedly, an extent of 83.75 square meter was not charged for, and in light of the discrepancy in execution of sale deed, as the entirety of the land available as a corner plot was not conveyed, the representation at annexure C has been made. In the peculiar facts of the case, the question as to what is the rate to be fixed for the deficit of 83.75 square meter, which was eventually conveyed by way of a sale deed on 5/3/2016 is must be on a basis that would result in maximization of interest of the state entity. The considering that the request made at Annexure C was in the year 2015. The endorsement issued at Annexure D fixing the rate as on the rate prevailing on the as on date of issuing the endorsement. Such action of the sole respondent cannot be faulted. The court ought to lean towards maximizing public maximization of interest of the state entity while dealing with such matters, and accordingly we find no reason to interfere with the endorsement at Annexure D. Accordingly, the petition is rejected.
Right.
Is there some such principle? Find out.
Yes, I shall.
Serial number 21, Prasanna Kumar P.
Statement. Just for 10 more days to file my affidavit. Last occasion, the Lordship direct me to file affidavit, whether the alternate place is available to shift the bus stand and the water tank. To that effect, direct me to file affidavit. I need 10 more days.
Relist the matter at request made of on behalf of counsel for R1 on
31st.
Please.
Serial number 22, Sunil T. Serial number 22, Sunil T. Serial number 22.
Is an office objection recalling. Huh? It's noticed that this court, by order dated 21st of March 23, had dismissed the petition for non-prosecution. The IA for recalling the order for dismissal of the petition for non-prosecution came to be filed on 30th October 23. IA 1 of 23 has been filed seeking for condoning the delay in filing the application for recalling. Office objections have been raised on the said application seeking condonation of delay filed as IA 1 of 23. Despite office objections having been raised, same has not been complied with. Court noticing that application for recalling and condonation of delay in filing application to recall the order of dismissal had noticed that there was no representation on behalf of the petitioner and adjourned the matter to be posted in the orders list on 17/1/24. The order passed on 2/1/2024 reads as follows. Next. In the matters called out, there is no representation on behalf of the petitioner. Noticing that the matter was dismissed for non-prosecution and objections have been raised on IA 1 of 23, filed seeking condonation of delay in filing the application to to recall the order of dismissal and noticing that there is no representation on behalf of the petitioner and the matter is called out. Clearly, the case reveals, the conduct of the petitioner reveals that he is not diligent in prosecuting the proceedings. Accordingly, IA 1 of 2023 is dismissed for non-prosecution. Consequently, IA 2 of 2023 is dismissed and records and file is consigned to records.
Serial number 23, Girish MK, Rekha KL.
My lord, appearing for respondent number 5 to 7. My lord.
Yes. They've encroached upon lake.
No, my lord.
Is there a stay?
There's no stay. No.
You read an annexure A, read annexure A.
My lord, actually the issue in this is
Yes.
petitioner has acquired site through gift deed from his mother, and Khata is still standing in her name. So second respondent had given notice under section 104 of Karnataka Land Revenue Act encroaching the water canal. So he had approached this court to quash the notice issued by the respondent number 4. So they have to comply with the office objection. Petition.
No representation on behalf of the petitioner when the matter is called out. It is this court has passed an order on 2/1/2024 which reads as hereunder. As a final opportunity, matter is adjourned to short date, 1 vara time. It's made clear if no office objections are complied with by the next date, necessary orders will be passed. List the matter on 23rd in the same stage. Isn't better. It is noticed that the office objection raised at seal number 1 has been complied with, as there is identification of the executant by the council in the affidavit dated 10/10/2022. Insofar as the office objection raised in annexure G, same is kept open. However, there is no representation on behalf of the petitioner. Relist the matter finally week after next. There is no representation on behalf of the petitioner, the matter is called out. Yes, date good.
23rd.
Yes.
Serial
Meanwhile,
number-
state find out. You have given notice that he has encroached upon. So what has happened, you find out by the next day.
Serial number 24 is.
My lord, I will undertake to. My lord.
Yes.
I will undertake to file wakalat on behalf of respondent number 1, my lord.
Lord Counsel.
Filing the report, my lord.
Also appearing through video conference.
Sunil Kumar Bandari.
Learned Counsel Sri Sunil Kumar appearing on behalf of appearing through VC undertakes to file wakalat for the first respondent.
Please, my lord.
Yes.
As per the direction of this honorable court, I'm filing the report which says that site number 37, if my lordship sees page 4 of the report. There is a sketch,
I-
my lord.
My lord, I placed time, my lord.
That site number 38, there is an existing building, there is no plan. As far as site number 37 is concerned, this is a vacant land. One property is of the petitioner and
Now,
one is of the
38 is
respondent.
being constructed by,
The respondent number one.
Respondent.
now petition, there's no plan.
There is no plan.
No plan, no approval. And
Now you have sought for initiation of action against him by
yeah,
BBMP.
no. BBMP, I had sent a notice in 2021 itself
So
to the,
You are seeking action against the first
yes,
respondent.
yes. ಆಮೇಲೆ ಸೆಟ್ ಬ್ಯಾಕ್ ಬಿಟ್ಟಿಲ್ಲ ಸ್ವಾಮಿ ಇದರಲ್ಲಿ ಇಫ್ ಯು ಕ್ಯಾನ್ ಸಿ ಅರ್ಲಿಯರ್ ದೇ ಕನ್ಸ್ಟ್ರಕ್ಟೆಡ್ ಅಪ್ ಟು ಫಸ್ಟ್ ಫ್ಲೋರ್ ಸಬ್ಸಿಕ್ವೆಂಟ್ಲಿ ಇನ್ 2021 they started second floor and the terrace and on 2021 we sent a notice to the BBMP commissioner also and they were using my vacant land also on this construction material. We filed a police complaint also against this. Iga what has happened is, even if you take it, even legal sanction, they are not supposed to build the second and the fourth floor in the fourth floor. There is no sanction, there is nothing, no approvals of anything, except somehow have managed to get electricity. Water supply has not been given, but in the report they say water supply, Bangalore water supply, Kaveri is there in that area. They have not given that connection because of this plan sanction approval.
When was it built? When was the building built?
The building was built in 2010.
2010.
ಅದು ground floor ಮಾತ್ರ. ಆಮೇಲೆ first floor was built in 21 and second and the terrace was built in 2022. At that time 21 itself we sent a letter to the joint commissioner as well as the administrator of the BBMP. ಈ ತರ illegal construction ಆಗ್ತಾ ಇದೆ ಅಂತ. It's on
My lord, may I request my lord to have it on
page number 20 Swami, annexure C. Unauthorized, it is sent to administrator as well as the chief commissioner BBMP. Page number 20, annexure C.
Now, yes.
And
further
My
action, I
lord.
will report, my lordship.
Further?
Further action, some time may be given, I will report the further action.
Initiate proceedings under 248.
248.
My lord.
Will record your undertaking, except the ground floor. Ground floor is in the year 2, will not enter into the ground floor because it's built long back. So except the ground floor, you initiate proceedings under 248 as per law.
My lord, I may be permitted, my lord, a week's time may kindly be given, my lord. I will make my submissions, my lord. Yesterday only I will get instructions to.
No, correct. What submission you can?
My lord,
There's
I will
no
put,
plan.
my lord, we are given a representation and other things, my lord. The petitioner was the sufferer of the order by the civil court, my lord, where he has
That's a
lost the
different matter.
property.
Now,
to
we are not entering into merits, sir. I'm only asking the BBMP to take action in terms of 248. There you will be given notice, you defend it. We are not
My lord.
entering, we are not passing any adverse order. We are only asking the BBMP to take action in accordance with law. So I am not passing any adverse order according to you. The petitioner has filed the present writ petition seeking for issuance of writ of in the nature of mandamus to direct respondents 2 to 4 to initiate action for demolition of unauthorized / unlawful and illegal construction of building on site number 38 of respondent number 1 in violation of section 313 of the BBMP Act 2020.
Notice also has been issued, Swami.
The petitioner submits that a notice was issued
Annexure E, page number 23.
to the BBMP
23, annexure E.
the petitioner submits that pursuant to the representations of the petitioner, respondent BBMP has issued notice under 313 of BBMP Act 2020 on 18/3/22. It is however submitted that after the said notice at annexure E, no action has been taken by the respondent
Yes.
BBMP. During the pendency of the present proceedings, pursuant to a direction passed by this court on 29/11/23, the BBMP has carried out a spot inspection and has filed
Inspection report, compliance report.
Complaints and survey report.
a compliance report on 17/1/24. Which is a relevant column in terms of the said report.
Page 2, column 5 ಅಲ್ಲಿ ಇದೆ sir. Permission not obtained on anything.
In terms of the said report at
Roman 2.
Roman 2 also.
At serial number 2, Roman 2, it is pointed out that as per the office records,
My lord,
There is
Roman
no-
2 and 3 ಎರಡು mention ಮಾಡ್ಬೇಕು.
there is no planned sanction. No records available regarding planned sanction or regarding building license obtained. Full stop. At Roman 3, there is a further observation in the report that there is no commencement certificate obtained as per records of the authority.
My lord, 4th also Roman mentioned because if you look at the photograph, there is no setback. Cladding ಆಗ್ಬಿಟ್ಟಿದ್ದಾರೆ. The neighbor, we cannot build a building. It will be joint ಆಗ್ಬಿಡುತ್ತೆ.
The said report further would point out that no, we'll see, we'll leave it at that.
4, Roman 4 ಅಲ್ಲಿ.
No, let us see, we'll not
Okay.
enter into the.
Okay,
Full stop. Learned counsel for respondent BBMP submits that pursuant to the notice at annexure E, further action would be taken in light of the findings that have come out on the basis of the compliance report filed by this court. Full stop. That full stop. It is however noticed from the submissions made that the ground floor was constructed
In the year 2010.
Back 2010 or something.
in the roundabout approximately in the year 2010. If that were to be so, as power has to be exercised within a reasonable period of time, the direction passed directing the respondent BBMP to take action pursuant to annexure E is to be limited to construction put up apart from the ground floor. Accordingly, the petition is disposed of taking note of the limited prayer sought for. While noticing the undertaking of counsel for respondent BBMP, as also the BBMP being directed to take action pursuant to annexure E as per law in light of the report filed by this court. All contentions are kept open. Needless to state that the first respondent is to be afforded opportunity as per law while proceedings are initiated as directed. Accordingly,
Lord, I may be given liberty to file my objections, my lord.
in this
With
what
notices.
objection, on that you can, that I have kept open all contention.
Please.
Serial number 25, Nanesh Kumar K.
My lord, in serial number 25, my lord, I appear for the pleading applicant, my lord.
Yes.
Am I audible, my lord? My lord, your lordships, my lord, may kindly see, my lord, order dated 1/12/2023, my lord. Am I audible, my lord?
No, correct. Now order is passed.
Week's time may be granted.
My lord,
but
order is passed, my lord. My lord, what has happened is, my lord, they had approached this honorable court in this present writ petition. The lordship may kindly see order dated 1/12/2023, my lord.
No, have you filed an appeal?
My lord, they have also filed an appeal. There is a status quo order. Now, my lord, in the guise of the interim order granted by this honorable court, my lord, they are proceeding with the construction. And my lord, in a span of 1.5 months, my lord, 2 floors have been raised. There is no order, my lord, permitting them to construct. The order simply says, my lord, that there is an interim order of stay of demolition, my lord.
Now, where is the order in appeal?
My lordship, I withdraw the appeal, my lordship, before the commissioner.
You withdrawn the appeal?
Yes, my lordship.
Why?
Because I challenged the provision order confirmation before in this petition, my lordship.
You go back there only.
No.
My lord, in fact,
my lord, without serving the provision order, my lordship, confirmation order is issued, my lordship.
Once you file an appeal, how did you file the writ?
No.
When was the appeal filed?
My lord, earlier to the writ petition, my lord.
Page?
My lord, I don't have a copy of the my lord appeal memo. It is my lord appeal 80/2023. That is the information that is given by the legal cell, my lord.
80/2023.
Please, my lord.
Where was that appeal? When was the appeal filed? How can you do that, madam?
My lord, it's a case of suppression of facts, my lord, and placing
lord,
the
I need,
interim order
weeks
granted
of
by this
time.
honorable court, my lord. They're proceeding with the construction.
No, where is that 1 minute?
My lord, I seek for a weeks of time, my lord.
No. Why you are not complete with instruction? Are you helping him out?
No, my lord.
Then?
Kindly pass over the matter, my lord. I'll get the appeal now. The details and.
Yes, you find out
Yes,
date
my
of
lord.
filing the appeal telephonically.
Yes, my lord.
Whether you filed the writ after filing the appeal or before?
After filing, my lordship.
Then how is the writ maintainable?
Before the commission, my lordship, not taken as a condition that the provision order has been served, my lordship.
That
Has
is
not
what-
been served.
All that you raised there only.
No,
Now,
already
what is-
withdrawn, my lordship. The appeal has been withdrawn, my lordship.
You withdraw your writ petition. I will revive the appeal.
Lord, my only submission is, my lord, in the meantime, my lord, let them not proceed with the construction, my lord.
My lordship, he can't
No,
say.
I'm going to dismiss the writ petition. Forget about
Please.
the interim
My lord,
order.
but please.
Where have you stated regarding filing of the appeal? Writ petition is filed on 9/11/23. Where have you mentioned regarding filing of the appeal?
Lord, in the entire writ petition, my lord, there is no submission.
When was the appeal filed?
I have not filed, my lordship. So
2:30, you come back. I'm going to dismiss the writ petition. You seek liberty. I'll give you liberty to revive the. Tell me, find out the date of filing of the.
Please, I'll file.
Also.
Obliged.
Serial number 26, Dignum.
For the third respondent,
I appear for the petitioners, my lord, in this
I may
case.
be permitted to file my statement. My lords directed me to place on record all the materials where how I was appointed as a trustee, and also regarding my undertaking that I will be paying the property tax balance.
With my lord's kindly may I make a suggestion. We have filed caveat in this matter, but petitioners intentionally evaded us to make us a party. On serving a copy on the petitioner's side, we have already filed an application before the court. It is not put up. Swami, so our application may also be taken into consideration.
You are the?
We are on behalf of the trust, Modi Trust, to safeguard its interest, my lords, because since they have not made me as a party, and I can understand very well Mr. Subhash Modi's application also before this honorable court, claiming himself as a trustee. All those aspects can be considered. And the only question is that whether they being who are nowhere connected to the property, on obtaining one notice from the BBMP authority by setting up, they wanted to claim as a tenants of the premises in question belong to the trust. I am only in the interest of safeguarding the trust and its interest.
So correct, now, the only notice that is issued
Please.
is for payment of tax.
Yes, madam.
Isn't it? Now, I will observe all the impleading applicants, etc.
Please.
And keep it open for payment to be made. BBMP will accept from whoever pays. That the payment of tax will not confer any independent
Yes,
right.
madam.
That's all.
In fact, my
If
lord,
they were claiming
I have
to
a
be
document,
trustees,
my lord.
then I can understand.
Whoever
No,
pays.
they are not claiming.
No,
They are not claiming as
Please, madam.
trustees.
I
If
have
they're
a
claiming as
document.
Trustees, I can
No,
understand.
no, what I'm
Keeping
saying-
aside that regarding tax, I have a document. There was a concession on the given by waiving up tax as ours is a charitable trust by the BBMP. Those documents also required for placing before my lords
Let
to
us
show
see.
that there was
Let it-
waiving up of tax only in the interest of trust. It is not for me any personal interest, my
It
lord.
is stated that impleading application has been filed. Office to put up the same. Relist the matter on. Date.
My lord, in the mean,
23rd.
my lord, in the meantime, at least, the premises may be open, my lord, because the premises are the commercial shops, my lord. So, and there are perishable goods.
Just one statement of objections filed by R3 is taken on record. No, let us see, they say, will I
Because,
have
my
a
lord,
short?
the
No relation.
petitioners, one submission, but the petitioners are tenants under the third respondent, neither under this, neither under Subhash Modi nor under
No,
the
just-
impleading applicant.
We'll
We'll
see
have
how.
it, no, just one minute. We'll have it on Monday. Now, counsel for the impleading applicant states that there is some exemption. We'll look into it.
We'll
We'll-
show.
BBMP
Earlier,
will-
some letters are there.
Let us see.
We will furnish, definitely.
So in advance, you give it to BBMP.
Hey,
counsel.
I'll. Please.
Because,
Because
my lord,
only-
the
I'll serve.
the shops
my
are,
friend.
shops are, they are under lock since one month, my lord. So because the commercial shops, they are selling perishable goods, that is the reason, my lord. Because they're the occupiers and also they're ready to pay the tax and in respect of their portions, my lord, which measures 12 into 18. But now the notice has been issued, wherein, my lord, in the notice, my lord, the figures are varying. In one notice, they mentioned 10 lakhs, the amount due is 10 lakhs. In the other notice, they mentioned the amount due is 1 crore and 10 crores. So the notice itself is defective in the first place.
That aspect is concerned to trust and whatever may be my friends.
And now the dispute, there is a dispute between the third
They are
respondent and
not
the impleading
called
applicant, my
tenants
lord.
Also, my lord. Not
And the
even
same
a
has not been
scrap of
resolved.
paper.
Let us see, let us see.
Please.
At least interim order, my lord, as prayed for, my lord.
Monday. We'll have it on
Because
Monday.
there are perishable goods in the shop lying since 1 month, my lord. At least the shops may be, there may be an order, my lord.
Now, if tax is paid to the BBMP as per their demand or appeal is filed, there would be end the matter. I will consider everything and pass an order on Monday.
In the notice, my lord, the figures are varying because the amount due is 10 lakhs. So in one notice, it is 10 lakhs, and the other notice, it is 1 crore. Because the notice itself, whatever they've issued, it's not in the prescribed form as per section 147 of the BBMP Act, my lord.
They are not tenants at all, my lord.
If
They are not at all tenants, no relationship of landlord and tenancy. They wanted to squat over the property and to enter there under the guise of.
Let us see, we'll pass some order.
Please.
If that was the case, why was the caveat issued by them, my lord?
No, but the present matter.
We were not tenants.
We can't enter into the question of
Please,
who's. will-
Please, my lord, please, my lord.
Had filed suit for eviction, my lords. Once the trustee died, my lords, the proceedings were terminated because there was nobody to take care of to come on record. That's how that, my lords, those tenants have been enjoying the property. They're neither paying the rent to us nor paying the property tax. They're enjoying the property. That's how the tenants are there. My lords. They are taking the benefit of vacuum created now.
There is an history behind this, my lord.
The dispute is between the trustee and the administrator and not between the tenants and the trustees, my lord.
Now you
Because
also
of them, we are suffering, my lord.
Now you
That
also
is the
set up
reason, my lord.
presence of this eviction proceedings between two persons.
Because
I'll bring it to
if they say that we are not the tenants, why was the caveat issued, my lord?
The order, I have produced the order.
We'll
of
place
small cause
every
court
material before
where
the honorable.
Suit filed by the trust was terminated because the trustees died and the administrator could not represent the trust. So my learned friend is not right in saying that the petitioners are not tenants of the premises.
See, after looking into the matter, my lord can take. If they are right, their submission.
We'll have it on Monday.
Material.
But have it on Monday.
Second petition, my lord, the petition is running a courier shop, so that is the reason, my lord, the interim order has paid for.
Monday will dispose of the matter itself. Yes.
Serial number 27.
Meanwhile, just look into it, look into what is the claim made by BBMP, what is the, whether they are paid, not paid. They claim that there's an exemption.
Some long back, ನಮ್ಗೆ ಏನಿದೆಯೋ ಅಷ್ಟು.
Have a look at
Consider
it. And then
in
we'll-
accordance with.
See, now present dispute is only relating to tax. Once you get the tax, then let whoever fight.
Please. Other disputes, we do not want to.
Is there, if not, my lord, let there be a direction, my lord, to the petitioners to pay the rents,
See.
deposit the rents to the corporation, my lord. Let there be a direction, my lord. Because they're not able to pay the rents, my lord. That is the reason. Because there is a dispute between the trustee and the administrator.
No, that will not enter into, only regarding tax will pass some more.
Please, my lord.
Serial number 27. Smith S.
Matter pertains to ground rent. The court fee has been paid on 12th.
Third counsel for the petitioner submits, court fee has been paid, office to verify. List the matter along with the WP so and so.
My lord, sir, interim order, my lord.
Interim order earlier granted it? No.
No, the
First time.
Fresh matter.
Hmm.
Fresh matter. Just pass on the interim orders. Your lordship's order is there.
The
Only
demand is at annexure.
Demand is at annexure M, my lord, page number 170. Your lordship sees in page number 4, your lordship's order. Only thing is the serial numbers will change, my lords.
The same order.
Same order, only serial numbers will change. A will become, instead of serial number 1, it will become serial number 2.
You just mentioned that in pencil.
Yes, my lords. I have just mentioned it in my copy in pencil. I'll just pass it on, my lords.
So same order.
Same order, my lords. And only fresh/modified sanction plan, my lords. In the next page, where your lordships have granted direction to issue the plan, it is fresh/modified.
Pencil corrections and one correction.
One more submission, my lords. The name of the petitioner is Carley Infra Private Limited, Infra Projects Private Limited. It's become Infra Projects Private Limited. It's the earlier iteration of the petitioner. I may be permitted to correct that one name, my lords. It's just Carley Infra Private Limited and not Infra Projects Private Limited. I've produced the certificate of incorporation and the change of name also.
Petitioner files a memo and seeks for correction of the name of the petitioner. In light of the memo filed, petitioner is permitted to amend the description of the petitioner.
Name of the petitioner.
Amend the description of the petitioner. Learned Counsel Shri Pawan Kumar accepts notice for respondent 2 and 3. DG accepts notice to the first respondent. Same order.
I'm grateful.
Serial number 28.
Regarding the reassessment of BBMP tax matter, on number 3 has read the premises matter. Some copies of petition matter regarding
Court fees, court.
I have paid them. I have received.
You paid. The counsel for the petitioner submits, court fee is paid.
Other objection, I can rectify. Kindly see the annexure A to after 5 years, my lord, annexure A to E, my lord. Page number 11. It is in the year 2016-17, my lord. And that also it is issued in the backdated, my lord. It is the order dated 36/20/23, my lord. But it is served with the petitioner, my lord, on 10/11/2023. My lord, annexure N, petitioner has filed the objection. after receiving this demand notice, where it is clearly stated that, my lord, it is a backdated, issued the demand notice on 10/11/2023. And that too, it is after 5 years, my lord, and 16, for the year 16-17, they now start for the reassessment.
No, insofar as beyond 5 years,
Beyond
what order we have made in the other matter is for that year, you don't have to pay any deposit. The authority will consider if it is beyond 5 years. Then you must undertake to file an appeal. If appeal is filed within 30 days, we will, if you make such an undertaking, we will lift the seizure and relegate you to go according to the appeal. You have to make the deposit in terms of
148.3.
148.3 while filing the appeal. We'll lift it, but you have to file appeal within 30 days. All contentions will be kept open. Now, which is the year beyond 5 years?
My lord, annexure A to C is the.
You have a look at it, at 230 will pass. This one and that other matter, which are the years beyond 5 years? 5 years from date of filing. That will keep it open, and you can't insist them to pay penalty and tax on that. Remaining, let them file under 179 appeal. Which is that order we passed?
334. He's having it. WP 334 of 2020.
It's the same order. Adena? Same. So we'll have it at 232. For that 1 year, we will keep the deposit in abeyance.
For that period, maybe let them not deposit any amount there, but that contention may be kept open. We
That
can.
order we passed in one of the matters. Same order will pass. But which is that 5th year, you'll have to verify. 230.
Hearing on a application matter, serial number 29, Arun Papi Reddy.
Last occasion, my lords, I had taken time to file the memo of calculation, my lords. I pray for another week's accommodation, my lords. It may be taken up next week. The concerned official was in some other work, so she could not approach me in time, my lords.
Relist the matter on
Tuesday, my lords.
Tuesday. Wednesday.
Obliged.
Will be hearing B group matters, serial number 30, Shivaramu MK.
Lordship, I seek 1 week's time to ascertain the actual facts of because the kata is issued or not, because it is related to the kata. So I'll check, verify and confirm before this court. 1 week's time may be granted.
You appeared for?
I'm for the respondent number 6, my lord. I'm the beneficiary. I'm the, my part owners applied for the kata, e-kata.
It is issued, is it?
I just ascertain and it's a long pending matter. I'll next week after week I'll ascertain.
Next week. Relist the matter on 23rd.
Actually.
You ask the council for R3
Verify. I'll verify.
or the other respondents for the panchayat. Find out whether what is it.
Achha.
Yes.
Serial number 31, KL Srinivas. Serial number 31, KL Srinivas.
Number 5. Matter. Annexure J. Is the order passed by the Adhyaksh of Taluk Panchayat.
Annexure
J.
J.
Then annexure M is the order passed by the Adhyaksh of Zilla Panchayat. The 5th respondent has approached the Adhyaksh of the Taluk Panchayat.
Page?
Page number 1.
Page 46.
What is this order at annexure J?
That's the order void annexure J is passed by the Salok Panchayat President. It is the third respondent here exercising the powers under section 237 minutes of the Panchayat Raj Act.
Then we have passed order saying that this is Kata, is it?
Annexure J and M has to set aside.
Annexure
J and M.
M is the appellate authority.
Adhyaksha Zilla Panchayat.
Jilla Panchayat.
Then the fifth respondent has to file an appeal before the executive officer.
So then under 269,
Yes.
power is liberty will be reserved.
Fifth respondent.
Huh?
Executive officer.
Under 269.
Yes.
We will dispose it of.
From 1961, 1962.
Position book
The
in
name, continue in my name. Suddenly, the Gram Panchayati.
I'll direct status quo, huh?
Please.
And within 3 weeks from date of receipt of certified copy, you file an appeal. The status quo will be in force till your request for interim clear is considered under 269. The order. The 237 of
Panchayat Raj Act.
That is the power to suspend the resolution.
Only the power is given to suspend the resolution.
Of
the
prohibit something doing.
the petitioners. So which is that other matter I disposed of? We have the number.
Oh, sorry.
The petitioner has filed the present writ petition calling in question correctness of the order at annexure J passed by the President Taluk Panchayat in appeal number 8 of 2010-11, as well as the order at annexure M, which is an order passed in appeal by the President Zilla Panchayat Mandya. Though, full stop. Next. The admitted facts being that the respondent number 5 had initiated proceedings in appeal 8 of 2010-11, challenging the resolution of the Gram Panchayat regarding affecting transfer of Kata made in the name of the petitioners herein. The challenge of the resolution affecting Kata before the Adhyaksha of the Taluk Panchayat was by invoking section 237 of the Gram Panchayat Act. Said appeal has been allowed and has been, what happened? That appeal was dismissed or allowed? Allowed. And as against such order at annexure J, appeal was filed
By the petitioners.
by the petitioners herein before the Adhyaksha of the Zilla Panchayat. An order at annexure M has been passed, whereby the appeal filed by the petitioners herein has been dismissed. Against such orders, the present petition has been filed. Learned Counsel Shri Somayaji appearing for respondent number
Respondent number 2.
2 submits that the order under 2
2 to 4.
2 to 4.
2 to 4 submits that the order at annexure J itself is one without jurisdiction. And consequently, the order at J and order passed at annexure M by the appellate authority required to be set aside. Full stop. Repeat para 3. The kata was initially done in the petitioner's name.
Please. The kata initially was made.
No. As against that you challenged it. Repeat para 4. Para 5 ಆದ್ಮೇಲೆ. The counsel for the petitioner, counsel for respondent number 5 would submit that by virtue of setting aside the order at annexure J, now the fifth respondent is to approach afresh, challenging the resolution of effecting kata in favor of the petitioner by separate proceedings, and in light of relief granted by the authority at annexure J, an interim protection may be granted. Taking note that the order at annexure J as well as M are being set aside, and noticing that the fifth respondent had obtained benefit of an order in proceedings at annexure J, there would be an order of maintenance of status quo as on date, which order would be in force till the fifth respondent seeks for appropriate redressal against the resolution affecting kata in the name of the petitioner by invoking section 269. All contentions are kept open. The pencil and corrections. The last limitation ಬಂದಿದೆ ಅದು ಇರಲಿ. ಆಫ್ಟರ್ ಪ್ಯಾರಾ 5 ನಾನು ಹೇಳಿದ್ದೆ, ಆಮೇಲೆ ಲಿಮಿಟೇಷನ್ ಒಂದು ಪ್ಯಾರಾ ಇದೆ, ರಿಪೀಟ್.
Serial number 32, P. Krishnappa.
For the petitioner, my lords.
Yes, respondents.
My lords.
Respondents 1 and 2.
The petitioner is the owner of the site bearing number 17/1, my lords. And this measurement is east to west 43 feet and north to south 12.6 feet, my lords. My lords, this property was purchased in 92 and they had put up the ground floor in the year 1992, my lords. That is when it was in Timenelli jurisdiction. Subsequently, the property has vested in the BBMP, my lords. And the year 2011 and 12, he constructed first and second floor. Now the BBMP has issued a provisional order in the year 2013 that there is a deviation of 100% in the ground floor. My lords, this was constructed in the year 1992, my lords. And Kindly see the measurement, my lords. It's east to west, it's only 12.5, 12.6, my lords, width. And if I leave the setbacks, it's only 7.6 feet. And there is
What
no,
is the measurement of the site?
my lords, east to west 43 feet, north to south 12.6 feet. Annexure J may be seen, my lords. That's a photograph. The only deviation is I have put up a staircase, my lords.
No, what is the measurement of the site?
My lords, east to west 43 feet and north to south 12.6 feet.
40 into 12.6.
43 into 12.6. And this ground floor was constructed in the year 1992, my lords.
No, now there is some plan is required with respect to other than
First and second floor have been
above.
built in according to plan.
They
my
have
lords.
obtained a plan for sanction plan for constructing the first and second floor. Now the staircase, if your lordship may kindly peruse the photographs that they have produced, it is on the road.
It's not in the road, it is within my property. That is the access to the first floor and second floor. That's ingress and egress, my lords, for the first floor and second floor. It is not to the
In
road.
fact, annexure A, my lord, I have specifically mentioned the dimensions, the construction which has been put up by the
I've
petitioner.
produced the photograph, the entire
deviation.
road, my lords. All those have been constructed the same way. Due to my neighbor's complaint, based on the neighbor complaint, the order has been passed by the BBMP. Now the neighbor has also sold his property and is gone.
You're correct, but it can't be on the road.
My lords, it's not in the road, my lords. It may be seen, my lord. I've produced the photographs. It's not on the road, my lords. It is within my property.
You replace it by
I've produced the entire photographs of the entire road, my lords. It
My
may be
lord,
kindly seen.
if your lordship may kindly peruse annexure A. The first floor, the plinth area is 27.74 square meters. And the construction is 49.78 square meters. And even on the second floor,
now the staircase is beyond.
yes.
What is the extent of the staircase? 2.13.
2.13, please, my lords.
That you replace it by a metal staircase, we'll see. That's the only solution.
But my lords, it is within my property, my lords. It's not on the road.
Correct, what we can do now?
It is within my property, my lords.
If you have a metal staircase, then that may solve the issue.
That's the ingress and egress to the first and second floor, my lords. That's the only way I've got.
Correct. So you replace it by a metal staircase. That then we can ask them to consider it, and then they may leave it at that. But you find out what can be done.
Next Monday, my lords.
We list the matter. When do you want?
By
You have to find out from your engineer also whether it's possible, etc.
Please,
And
my
then
lords.
you make a submission, then we'll ask them to consider it. If you put up a temporary replacement of that staircase by a metal staircase, then we can ask them to see whether it could be considered as deviation is removed. That's all.
2 weeks time, my lords.
At request made on behalf of the petitioner, list the matter after 2 weeks.
Much
Let
okay.
us
Much okay.
Serial number 33, Jagan Mohan MT.
This is the writ petition filed by the petitioner for writ of mandamus, directing the respondents to give 15 guntas of land, which they have formed a road without acquiring my land or even without paying any compensation.
Yes. Road is formed by?
Road is formed by the panchayat.
You appear for?
On the executive officer.
So now what is the position?
Mr. Pradeep Maharaj, they have contaction, they have with the randomers.
Pradeep Antikin.
M. Pradeep.
We'll have it at 2:30.
I'm sorry, I got the inconvenience. My lord, your lordship may kindly.
Next Monday.
Next Monday.
Monday.
Tuesday, I will not be in station. 23rd, I will not be in station. That's why I'm requesting you. 24th or 25th, any date.
Deal is the matter on 25th in preliminary hearing list.
Very well, very well.
Because it's
25th
only
in preliminary hearing.
Only on the point.
One is whether they have acquired or whether they have paid. They admit the road is formed. In the counter, they admit. Therefore, no difficulty. They admit they have filed the counter.
So the panchayat.
Yeah, panchayat.
They have not, panchayat has not filed the objection, Maharaj.
Your objection.
R3.
R3.
R3 fail
ಆಗಿದೆ ನನ್ನ ಹತ್ರ ಯಾರ್ದು ಇದು ಬಂದ್ಬಿಟ್ಟು ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಇದೆ ನೀವು ಹಾಕಿದ ಅವ್ರು ಹಾಕಿಲ್ಲ ಆಲ್ರೈಟ್ ಲೆಟ್ ಇಟ್ ಬಿ 25th ಲೆಟ್ us see what they say.
When Zilla Panchayat files, the Gram Panchayat is bound. Where you have stated the road is formed.
Yeah, kindly Tuesday, Maharaj.
It is. Yes.
Serial number 34.
Date may be.
Yes. Date.
25th.
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 Very well, please.
Serial number 34.
In preliminary hearing stage.
Yes, yes, ma'am.
Yes.
Sharath Gowda.
Of the petitioner, my lord.
Second
In this case, the petitioner's request for effecting kata has been kept in abeyance. The ground that earlier land has been divided without obtaining prior approval from the Mandya Development Authority, my lord. But originally, 5 guntas of land, my lord, belonged to one Noor B.M. She was purchased under a registered sale dated 1959, my lord, in the year 1959.
No, what is the, you have filed your objection?
Yes, I have filed.
So then they're saying there's no provision.
My lord, that ground, but in this case, out of 5 guntas, I have purchased an extent of 90 into 35, my lord. With respect to 45 into 35, which is adjacent to the petition scheduled property, they have given kata.
When is that?
But to that extent, my lord, the kata has been changed on 23/12/2004. Subsequently, my lord, in the year 2005, government issued circular in view of directing all the city municipalities to comply strictly section 17 of the Karnataka Town and Country Planning Act. A circular to that effect has been issued. So from 2005 onwards, my lord, we are strictly complied with the section 17 of the act. But now the document which is produced, so kata which was granted in on 23/12/2004. So the same kata has been continued. So that is the document which is now produced by the petitioner. It is not issued in the year 2013-14. It is of the year that I had document to show that.
But then what is the solution to all this? Now even earlier his vendor also had kata.
Yes, my lord.
That entire extent kata has been they changed after the conversion, of 5 guntas of land, after conversion, entire the Kata stands in the name of the original owner after obtaining the conversion order to the entire extent. A portion of which sold in favor of the petitioner. Thereafter, the petitioner filed application. So they have to obtain permission from the Town Planning Authority as required under Section 17 of the Town and Country Planning Act. Without complying which we cannot do.
Is it possible?
No, my lord, because in their endorsement itself, they
So
say
we
that
cannot issue.
it's not possible.
We cannot enter the Kata by violating the provision Section 17 of the Karnataka Town and Country Planning Act. And pursuant to that, various circulars have been issued since 2005 to 2008, 2023. Circular have been issued strictly to follow the Section 17 of the Town and Country, Karnataka Town and Country Planning Act. So we are bound by that. So that particular provision, the dishonorable court held that. So in order to the uniformity and the strict compliance of the Section 17, they have to obtain the plan sanction by the Town Planning Authority.
Section
17 of the Karnataka Town and Country Plan.
Town and Country Planning Act. Section 17.
Yes, 17.
No, then he has to, but who has to now go before the Town Planning Authority?
The person before a plot as sanction, that a conversion has been obtained by a person to the certain extent. Not suppose if he wants to sell it by dividing by making subdivision. But before subdivision, he has to approach the competent authority. So then after obtaining the permission, then only he can subdivide it and he can make, he can sell the properties. But suppose if without a subdivision, a person purchased a property, then he has to approach the competent authority under Section 17. Then he has to obtain the plan approval. Then he has to make an application. Otherwise, we could not regulate the compliance of the Section 17. But that has to be looked into by the planning authority only. This provision has been upheld by this honorable court.
Planning authority is a party, no?
No, ma'am.
To make the planning authority, let them take their stand. Let's.
Commissioner City Municipal Council is not part
The
of.
planning authority is not made as a party.
Now, who is the planning authority for this?
Manda Urban Development Authority.
We implead them. Let us see, and then we'll see what is to be done. Manda Urban Development Authority is a necessary party.
Please.
Taking note of the objections raised by respondent number 2. Who appears for that authority?
TP Vivekananda.
Land Council, the petitioner is permitted to array the Manda Urban Development Authority as a necessary party. Land Council TP Vivekananda is directed to appear on behalf of the said party. Necessary amendment to be carried out forthwith. List the matter on date.
1st of February.
No, correct, but then don't register sale deeds only. Let the government issue a circular stating that wherever this problem arises, sale deed should know. Now, suppose sale deed is, That circular, you place it. You collect a copy
Yes,
of the
madam.
circular. Let us see.
Yes.
Yes.
Serial number 35, Shivaldi Shriyogi.
For the petitioner in this matter. No, the prayer of the petitioner is not seeking writ of mandamus against the respondent authorities to enter, to transfer kata of the land bearing survey number 51 measuring 3 acres in Malasandra village. Not the petitioner in support of his prayer.
No, now what has happened now?
Not they are not acting upon the orders passed by the special deputy commissioner and special Tashildar. The orders which are produced at annexure H and L. These are the orders are passed in my favor in the year 2010 and 15 respectively, which they are not giving effect to these orders. Annexure H, page number 51, in which there is a clear specific direction is given by the special deputy commissioner. Not a relevant page number, that page 57 and relevant para, page number 57.
Page 57,
internal page. But annexure H
this
starts with page number
well,
51.
annexure H, I think those orders were set aside, isn't it? Some direction.
I'm not aware of.
Orders passed by that officer, government. Orders passed by that officer, all were set aside by some suo motu petition.
Not in my case, re-inquiry was
Just one.
conducted.
No, just one. There is some blanket order. You remember, isn't it? Find out. Relist the matter on date. There is some order. Find out.
There is one more order that annexure annexure L. They conducted re-inquiry on this order.
So let us see that.
Please.
Re-inquiry.
Re-inquiry means that the Tashildar, special Tashildar was directed by the deputy commissioner. This order was passed by the special deputy commissioner. On this order, inquiry was conducted by the Tashildar, special Tashildar, based on the direction of the deputy commissioner. This special Tashildar passed order on 6th February 2015, who has not conducted inquiry and hold that this order passed by so and so is proper and correct, and further directed to enter transfer kata in favor of the petitioners, which order also has not been given effect.
Okay, you take your stand. Have you filed your objections? There's a old matter, file it. Statement of objections to be filed within 10 days. List the matter. Date of February.
Serial number 36, Ranjit KS. Serial number 36, Ranjit KS.
Yes. What is this matter?
My lord, this matter pertains to discrepancy in the assessment of tax, my lord. My lord, the contention of the petitioner is that we have assessed less than the prescribed norms as per the Gazette. In fact, your lordship, the contention of the petitioner is that we have calculated at ₹25 per square feet, but it is on square meters which we have assessed.
Let him come. But you filed your.
Yes, my lord, please, my lords. I have filed my objections, my lord. It is ₹26 as per the petitioner. In fact, we have collected around ₹32, my lord. Per square meter, it is 10.76 square feet into 3 as per the resolution at ₹3 per square feet. It comes up to ₹32. There is a profit of almost ₹6 to the Gram Panchayat, which is not within the knowledge and notice of the petitioner. In fact, there is actually a excess collection, my lord.
By ₹6.
Also.
Then this has to go.
Their contention is that it is undervalued as per the Gazette, but on square meters we have assessed. 1 square meter equals to 10.76 square feet into 3 as per the Gram Panchayat resolution. His contention is that it is 25 or 26 rupees, but it is around 32 rupees per square feet, which we have collected.
No, he's the landowner.
No, my lord, he is one of the ex-Gram Panchayat members.
So he is complaining.
Please,
that
please, my lord.
it's-
And also there were some discrepancy regarding other setback and wastewater flowing and segregation of waste. All those things have been complied and guidelines have been issued since it was unoccupied by the
No
petitioners.
representation on behalf of the petitioner. It's noticed that on 2/1/24 as well, there was no representation on behalf of the petitioner. Made clear that if on the next date, the petitioner, there's no representation on behalf of the petitioner, adverse orders would be passed. This is the matter in the orders list on next week data. If it doesn't come, we'll reject it.
Please.
25th.
25th, yes.
Serial number 37 adjourn. Serial number 38. Prithviraj BN.
Yes.
For the petitioner. The last occasion, AGA was directed to seek instructions for the previous sanction of the government under section 72(2) of Municipalities Act. Auction was held in the year 1977. Approval was granted in the year 1988. Jilla Panchayat gives approval in the year 1991. Sales certificate is registered in the year 1991. And now some anonymous, two persons who are inimically disposed against me, they give a complaint saying that auction proceedings are not conducted in accordance with the proper procedure. And straight away it is set aside. The kata which is registered in my name is set aside.
Yes.
But three properties were auctioned on the same date. Let them get back whether sanction is taken for what action has been taken with respect to other two properties also.
Let us see.
Because only my property, the kata, they have complained. If previous sanction was necessary.
So when was the auction done?
In the year 20th August 1977.
1977.
1977.
And complaint made on?
2013.
But how can?
36 years almost.
After 36
years.
Okay, you get ready on the point of exercise of power within reasonable period of time. Get authorities on the point, let us see.
Promissory estoppel is there, but one of the defense taken is no against the statute, promissory estoppel cannot.
Correct. Exercise of power within a reasonable period of time.
Yes.
So that on that point you get some judgments. Let us see.
One state of Punjab versus Nestle India is there. I'll cite on the next day.
Get it and come.
Yes.
You have it?
I have.
Supreme Court.
Supreme Court. Sorry. Para 22, I will read. This is a case where.
Huh? You file it, but whether after now it has been auctioned in 77, how after 36 years you can seek to reopen? File it, let us.
The question is that the auction is done by Panchayat, the then Panchayat, had no right or power or authority to do that because the property belongs to the government. It could not have been auctioned by the Panchayat, sold by the Panchayat.
After
Under the
Correct, but after 36 years, how?
My lord, the delay is not the question, my lord. The question is whether the property belongs to the panchayat. My lord, I am appearing for the municipality now, present municipality.
DC himself records that the
And a
property,
tank, my lord, it's
it
a
was-
tank, water reservoir, that has been dried up. That was sold to the petitioner.
land has been made over to the
That cannot be.
municipality. That
These
is,
are lands and under section 67 of the Land Revenue Act
Not-
as well as the,
Not after 30 years.
my lord, 30 years
Adverse
also, my
possession,
lord.
adverse possession
No,
against the state
adverse
is,
possession, he has to go to before the civil court.
No,
Here, my lord, the question is, if it is not my property, can I sell it? If it comes to light later, but the government property, panchayat cannot sell it. That is all. Of course, it is my mistake.
no action
Some panchayat president has been,
that you can't, you should have taken action immediately, not after 30 years.
no, my lord, the matter came into light by the deputy commissioner later. My lord, the government's property cannot be sold by the panchayat at all without any permission.
After 30 years, even government loses rights. That is only now,
My lord, that
if power is now,
that he has to apply, establish before the civil court.
whether you have power after 30 years to set aside the kata into, not after 30 years.
Let them file the statement of
correct.
objection and I will also
No,
file
let
my
them file.
objection.
No, you file it. Now, after, suppose you are exercising power to cancel the kata on the ground that it could not have been sold. That exercise of power also must be within or 30 years, which is provided for adverse possession. If it is not done in that time, then you can't exercise power. You can't after 50 years, 60 years get up and say,
The public trust doctrine will come into play. my lord.
even
Anyway, my lord,
factually, what he has stated is wrong, my lord.
let the state file, let us. State to file their statement of objections.
Somebody sells it. My lord, can it be changed after 30 years?
No, correct, but now you have to take action now. Justice
The
Thakur.
deputy commissioner has taken right action in the right time when he comes to know about the mischief.
That's not the answer. Justice Thakur's judgment, you have a look, in which suo motu power was sought to be exercised. And the contention raised was the government came to know about that within recently. The Supreme Court said that you are the holder of all records. You can't say, I came to know now. You can't say that. Let us see.
Please, my lord. Because it's a public property, my lord, one should save it.
But not beyond.
And that too, a water body, my lord. Water body, when it's dried up, it has been sold to somebody. We are
Deputy
the
Commissioner
trustees
himself
of
records at page 16
government
that
property
it
as
has
well as
been
public
made over
property.
to the municipality in the year 1964.
In the year 1960.
64, he is quoting the order also. Under section 71, it has been made over
Let
to.
us see. It may not be permissible, not after the time prescribed by the state to take action.
From
In-
1964
for the
onwards,
civil
this is municipality property. Even as per the order of
Let us see. File
Deputy
your
Commissioner.
Is the matter after 3 weeks? Yes.
Serial number 39. Nagraj.
My lord, may I request for any date, my lord? Any date after 3 weeks.
3 weeks have been date. I am not going to touch till the file statement. Date code.
12th of February. Serial number 39, Nagraj Reddy.
Say for the petitioner in this case. Writ of mandamus seeking a direction to issue death certificate.
No, but now what is the legal position now?
Rule 5 milots says milots within 21 days milots from the date of information, the death certificate has to be issued.
My lordships, writ petition itself is not maintainable because the application has not been filed, my lordships. To
Huh?
issue, writ petition itself is not maintainable, my lordships, because no application has been filed before the authority to issue death certificate, my lordships. Son of the applicant has been filed an application, my lordships. So the maintainability itself is not there, my lordships.
No, let us see. Rule?
Rule 7 milots, Rule 5 milots, Rule 5. Register of deaths, births and death rules.
subclass 3 of rule 5, my lords. It says, my lords, the information referred to in subsection 1 shall be given within 21 days from the date of birth or still death, as case may be. Lords, the power of the registrar is, my lords, section 7.
Now under rule 5 subclass 3.
Yes, my lords.
Information is to be given under subrule 1 within 21 days.
Yes, my lords.
By
Section 6, my lords, section 6, section 8 and 9 says, though, my lords, concerned authorities have to give information, but it will not restrict, my lords, to give information by any other person. Section 8, persons required to be registered births and deaths. At the first instance, my lords, the BBMP told, my lords, the hospital authorities have not given information on that. Adhike, my lords, have filed the writ petition directing the authorities to give information. It is not necessary the hospital has to give information. It may be by anybody. And there is a judgment also, my lords, which is produced at Annexure D.
now 8 is only insofar as public by.
Yes, my lords. 8B may kindly be seen, my lords. In respect of births and deaths in a hospital, health center, maternity, or
Now here death is where?
in the hospital.
Hospital.
Yes, yes.
After hospital.
So the medical officer in charge.
Yes, yes.
Under 8B.
8B.
So now he has not given.
ಈ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಹೇಳಿ ನಾನು BBMP ಮೇಲೆ ಹಾಕಿದ್ದು. The hospital authority says, my lords, the second wife has given objection saying her name also included along with the petitioner anta. Subsequently, they have come and placed objection before this honorable.
Where is that?
Objection ಹಾಕಿದ್ದಾರೆ ಸ್ವಾಮಿ BBMP ನವರು ಅದರ ಜೊತೆ ಅನೆಕ್ಸ್ ಮಾಡಿದ್ದಾರೆ. Annexure R1.
Yes, read R1.
Please, my lords. Para number 2 ನಲ್ಲಿ ರಿಲೆವೆಂಟ್ ಪೋರ್ಷನ್ ಓದಿ.
Yes.
ಈಗಾಗಲೇ ನಮ್ಮ ತಂದೆಯವರ ಮೊದಲನೇ ಹೆಂಡತಿ
No,
ಮಗ
this is the objection by the other.
Other wife's son. I made them also party in this case.
No, correct. So now whether the hospital has given information or not.
Not given, my lord. Subsequently, my lord, the BBMP has said, my lord, this has been given anta. ಅಲ್ಲಿ ಹಾಸ್ಪಿಟಲ್ ನವರು ಇನ್ಫಾರ್ಮೇಶನ್ ಕೊಡೋದಕ್ಕೆ ದೇ ಹ್ಯಾವ್ ಟು ಅಪ್ಡೇಟ್ ಇನ್ ಎ ಪೋರ್ಟಲ್ ಅಂತ ಕಾಣಿಸ್ತಾರೆ ಇದರಲ್ಲಿ ವೆಬ್ಸೈಟ್ ನಲ್ಲಿ ಅವ್ರ ಪರ್ಟಿಕ್ಯುಲರ್ ಇದರಲ್ಲಿ ಅದನ್ನ ಅವ್ರು ಕೊಡ್ಲಿಲ್ಲ ಅಂತ ಹೇಳಿ BBMP has not issued. The ground for not issuing, lords, ಅವರು ಎರಡನೇ.
What is the stand taken by the BBMP regarding the non-communication by the hospital?
ಅದ್ರ ಬಗ್ಗೆ ಏನು ಹೇಳಲ್ಲ, ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿದಾರೆ, ಅದಕ್ಕೆ ನಾವು ಕೊಡ್ಲಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ.
No, para 6.
The averments in para 2 of the writ petition, the state as that the husband of the petitioner be Venkatesh son of so and so lost his breath on so and so in Aster Hospital, Bangalore during the course of treatment. In this regard, the hospital authorities have issued medical certificate of cause of death of the husband of the petitioner. After the death of the said person, his corpus was buried in their property during survey number 64.
Now, correct. Now the fact that he died in the hospital, any record?
Yes, yes.
Where is that? He died in the hospital.
Please.
Do you have any record of that?
Hospital ಸತ್ತೋಗಿರೋದಕ್ಕೆ there is no dispute, lords.
No. If there's any record, we'll take note of 8B and direct them then to take note of it and make an entry.
They have made as past. Respondent number 3 is the hospital here.
Respondent number 3.
3 is the hospital.
Who appears for R3?
Aster Hospital appears for R3.
Huh?
Aster Hospital.
Yes.
Annexure B, my lords. Annexure B is the hospital record that's showing.
Notice code. Annexure B.
B. Page number 11, my lords, of the writ petition. Medical certificate cause of death.
Yes. Where is the reference to his death? Cause of death.
Please.
Severe head injury with bilacerated.
So the fact of his death is not in dispute.
Not in
No,
dispute,
ma'am.
Your Lordships.
And hospital has also stated the cause of death,
Yes, ma'am.
isn't it?
Yes, yes.
So under 8B, they should have given it to the BBMP.
You need
Under
not.
8B.
Yes, yes, my lord. As per-
Hospital, he should have communicated.
Please, ma'am.
So that not having been done, after 8B, then what happens?
I have filed an objection, my Lordships. Respondent number 4 and 5 has filed an objections to it, my Lordships, stating that I am the second wife and even my name should be entered into the death certificate of my husband. my
No,
Lordships.
correct. Now, the fact remains that the name of the dead person is to be included.
Yes,
Yes,
ma'am.
my Lordships.
Just one.
Yes, yes.
Now, who wants their names to be included there is a different matter.
Yes, ma'am.
Let the dead man be first dead.
Yes, yes.
Yes,
ಇನ್ನು
my lordships.
ನಮ್ಮ petitioner ಹೆಸರು ಇಲ್ಲದೆ ಇದ್ರೂ ಕೂಡ ಪರವಾಗಿಲ್ಲ. What we needed is not the death certificate.
My
Where
lordships,
is the provision to say that the person, that the other person's name must be?
No, my Lordships,
Illa.
that is not there, my
Then
Lordships.
we'll clarify that. That you are ready, then we'll take
My
it up.
Lordships, on the last date of occasion, court has come to the conclusion that no names shall be
That's right.
issued. Only the death certificate may be issued with a dead person's name, my Lordships. We are okay with that, my Lordships. If that is issued,
ತಂದೆ
we are
ಹೆಸರು
okay
ಹಾಕಿ
with it, my
ಕೊಟ್ರೆ ಸಾಕು.
Lordships.
ಹೆಂಡತಿರ
Come at 2:30.
Obliged.
Let's, my request
So
not for
unless,
tomorrow, lords.
Unless there is any provision
Huh.
which says
No provision as such.
that in the death certificate, though there is a column in the death certificate wherein the other names are included.
Yes.
The practice being followed.
Yes, ma'am.
But if that is not there in the scheme of the act, we will say that the name of the dead person is to be included in the register.
Yes, my Lordships.
And there ends the matter. This dispute, if it's not there under the rule that somebody else's name to be,
Not because of the partition suit pending before.
no, that's okay. But the fact remains that one person who's dead does not find a mention the death. Tomorrow, we'll have it tomorrow.
Yes, my Lordships.
Tomorrow.
ಇರ್ಲಿ ಸರ್ ಮಧ್ಯಾಹ್ನಕ್ಕೆ ಇರಲಿ ನಮ್ಮ ಕಲಿಗೆ ಇರ್ತಾರೆ.
ಅಲ್ಲ, ನಾಳೆ senior ಇಲ್ಲ.
Senior ಇಲ್ಲ. Yes, ma'am.
Tomorrow at 2:30.
Please, please, 2:30. Yes, ma'am.
This is the matter. Tomorrow at 2:30.
Please.
All mention at 2:30.
ಮೇಡಮ್ 35 ನಾನು ಇಲ್ಲ ಅದರಲ್ಲಿ, ನಾನು ರೆಕಾರ್ಡ್ ಇಲ್ಲ. 30 and 33 ಇದ್ದಿದ್ದು 35 ನಲ್ಲಿ
ತಗೊಳ್ತಾರೆ, ಇನ್ನು first ಅಷ್ಟೇ ಮುಗ್ದಿಲ್ಲ. First ಅಷ್ಟೇ ಮುಗಿದ ನಂತರ second ಅಷ್ಟೇ.
Photo officer? Photo officer, madam? Madam, court officer?
ಬನ್ನಿ, ಒಂದ್ 3 ಮ್ಯಾಟ್ರ್ ಇದೆ, ಅದ್ ತಗೊಳ್ತಾರ ಅಥವಾ ಕಟ್ಟೆ ಇದು ಇನ್ನು ಫೈನಲ್ ಇಯರಿಂಗ್ ಒಂದು ಪೆಂಡಿಂಗ್ ಇದೆ, ಅದನ್ನ ಮುಗಿಸ್ಕೊಂಡು ಹೋಗ್ತೀನಿ ಅಂತ ಹೇಳ್ತಾರೋ ಕೇಳ್ತೀನಿ ಸರ್.
Sir, court officer?
ಹೇಳಿ
Sir,
ಸರ್.
sir, serial number 40 ಇದೆಯಲ್ಲ?
ಇನ್ನು ಕಾಲ್ ಔಟ್ ಮಾಡಿಲ್ಲ, ಕಾಲ್ ಔಟ್ ಮಾಡ್ತೀವಿ ಸರ್ ಮಧ್ಯಾಹ್ನಕ್ಕೆ.
Thank you, sir.
ಸರಿ ಸರಿ, ಹಂಗಾರೆ ಊಟ ಮುಗಿಸ್ಕೊಂಡು ಬರೋಣ ಅಥವಾ ಸರ್ 39
Serial number 14, request for adjournment.
Lords, I appear for the.
Which list?
This list.
19291.
Enabling us to file counter to the petition request for adjournment by 2 weeks.
2015 matter.
It's my matter, my lords. I appear for respondent. Respondent 4.
That's why I don't want to adjourn. 2015 matter, by next date be ready. List the matter. Date code, 10 days ago. 29th.
Lords, list number 2. Lords, list number 2, serial number.
Inform the other side.
We will.
You should inform in my court in advance. Just inform the other side. Because I don't want them to come and wait.
Indeed.
My lords, list number 2, serial number 33, my lords.
Grateful.
Writ petition number 27297.
List number
2, serial number 33.
Yes.
My lords, appeal we approached the High Court seeking an interim direction, stay of the confirmation order. The confirmation order is stayed by this court until the appeal is heard and disposed of. Appeal is being heard, my lords. Appeal is coming up on 20th. Kindly have this matter on after 3 weeks.
One submission.
No, how can the order be till disposed of? Till they consider the interim order, that's all. Huh?
But the order was like that.
Okay, that's the order.
That's
At
the
that
order.
time, their appeal was not considered. They have filed, but it was not put up on board. The ordinance bench said they will consider appeal until that you don't take any precipitative action. What happens during the pendency of the appeal status quo? Normally we grant status. It means that they should also not further construction. As
My lords, in the appeal, what has
Just wait.
subject to the decision of the appeal, further action will be initiated. If they succeed there, well and good. If they don't succeed, we will initiate further.
No, why keep it pending now?
This will be disposed of.
My lords, before the Chief Commissioner has said, since there is a stay in the High Court, I will not grant stay in the appeal. So we'll hear the appeal and dispose it of early.
Okay. So what? Now there's an interim order by this.
Yes, my lords. Directing the respondents not to take precipitative action till the appeal is heard and disposed of.
So you just wait, we'll take it. We'll pass an order. Wait. Why you want to take an adjournment?
Lordships may have it after.
No, we just wait. We'll pass. We'll dispose it off. Do you complete any of this some interim order? We'll observe.
My lord, filing a memo, my lord, there is urgency in this matter. BBMP has issued a notice for cancelling my trade license, my lord. So there is urgency, may be taken to.
Fresh matter.
Fresh matter. Today.
Number again. You have filed the writ?
Yes, ma'am.
Huh? Right.
In submission, today I filed a petition by challenging the BBMP order. So
what order?
They are cancelled the trade license and sealed the entire premises and locked down the entire premises. So there is an a dialysis center and logistics office, so many commodity office. So
on what ground? On what ground they sealed it?
They are stating that the tax is pending from the owner.
Then you have to pay that. No?
Because the owner has already paid the 2021-22 and 22-23 tax. There is a tax paid receipt, but their calculation we already sealed down the entire premises.
You have it tomorrow, but you will have to implead the owner.
Owner is a respondent.
He's a respondent.
Yes.
And then he has to pay the tax or he has to file appeal. Without that, we can't pass. Let us see. We'll have it tomorrow.
Please, kindly have it tomorrow.
Tomorrow.
Please.
But in all matters, we are passing standard orders, wherein you have to, in case of demand raised, you must file an appeal. And if you undertake to file appeal, or you undertake to pay the tax, or the landowner undertakes to file appeal within 30 days, then we grant stay and we can order directing them to remove the lock, the sealing of the premise. You must, otherwise you must undertake to pay the tax demand.
Please.
Let us see, get instructions.
Please.
Yes. tomorrow.
My lord, list two, my lord, serial number 16, my lord. Appearing for petition, will kindly have it in next week, my lord.
These two serial number
16. my lord.
you have informed the other side.
I shall inform, my lord. ಈಗ inform ಮಾಡ್ತೀನಿ.
ಮುಂಚೆ ಮಾಡ್ಬೇಕು ನಮ್ಮ ಕೋರ್ಟಲ್ಲಿ retrospective. The that request made on behalf of
Petitioner, my lord.
petitioner. List the matter week after next.
Any date.
Let us see, no urgency, let it come.
Entry order may take it.
Interim order earlier granted is extended till the next date. Huh? A memo haki. Lord Counsel for the petitioner files a memo and submits that by bona fide lapse, interim order earlier granted was not extended on the last date. Taking note of the same, interim order earlier granted is extended till the next date. I don't want them to come and wait. Huh?
Serial number 1, pass over. Company Venkana Ji.
We appear for petition.
Same one. Yes.
Petition on the day. This is issued to them. Connected with my lordship has says for last 5 years, they have to deposit 50%. Remaining contentions will be kept open. For how many years BBMP can ask for? Let the session.
We'll leave that open.
For 5 years, let them deposit 50%. They can minus the requisition they have.
Para?
Para 10. Para 10. There are total 7 show cause notices issued.
192.
For those years,
2016 and 17.
okay, so for those years beyond 5 years,
Yes.
we will, you don't have to pay the deposit. And the contention raised by you, saying it's in violation of section
148.
140,
148(3).
144 subsection 16. My lord. 16 which gives says 144 subsection 16, my lord.
so that we'll ask them to consider while.
No, before that, we'll pay, the deposit is 50%. 50% of the disputed tax mentioned in this.
That is a statutory scheme, I can't help. That is between you and the BBMP. BBMP decides they can relax it, it's up for them.
Double the tax they have mentioned in given notice.
We can't do anything, that's
By the amendment, that has removed double the tax.
Yes.
No, my lord.
No, this is lordship section 144. 6. Act number 12 of 2023. 144 6 subsections.
No, where is that 144?
6, my lord. Down, the orders double the tax payable which shall be omitted by Act number 12 of 2023. That is on with effect from 10/3/2023. Yes, In the demand notice, they have imposed a double tax, including penalty.
Where is the order?
Demand notice are at annexure E1 to E7.
Now penalty is levied under which section?
140, payment of property tax.
Penalty, column number 2.
No, penalty is levied under which section?
Somewhere in 144 only, my lordship.
144. His penalty is under 144(6).
No, no, my lordship, it's not under 6.
Now 144(15)(b). 15(b). Now whether this has been amended, we don't know.
No, my lordship, no amendment is done.
Huh?
No amendment is done, my lordship.
Only to 6 it is there.
That is in respect of government properties, my lord. 6 is with respect to government properties. Government land or land belonging to any local body, statutory body or an organization owned and controlled by the government, subsection 6 says. Then the proviso is in consonance with subsection 6. Because in all cases we have interest plus penalty, we have.
No, that is a matter at that point of time you will have to raise, not here. That you sort it out with the BBMP while you file the appeal. Only beyond 5 years I will clarify and keep that contention open. And insofar as tax and penalty for the period beyond 5 years, that I will observe that they cannot insist on payment payment of statutory deposit, as that very question is a matter to be decided in the appeal.
Humble Sub-Minister, disputed tax may be.
That I can't, I don't have power. That at the time of filing the appeal, you ask before the BBMP, let them consider. I orally indicated to him, it appears to be a little harsh, but then that's a policy decision to be taken by them. I cannot give a direction to that. The petitioner has called in question correctness of the order. No, but that you look into it at the highest level, let them examine it.
I have already
let them reflect upon it. The petitioners filed the writ petition challenging the demand, challenging the order at annexure E7.
Yes, sir.
No, where is the orders?
Orders is last pages, my lordship.
Huh?
Under E, E1 to E4.
Order and demand note on the same date.
Challenging the orders and demand notices at annexure E to E7.
E7.
E to E7. whereby orders have been passed reopening the self-assessment and demand notices have been issued. Now, they have not sealed the premises, isn't it?
Not so.
Various contentions have been raised regarding non-adherence to requisite procedure. Next. It is to be noticed that insofar as the orders at E to E7, which include the demand notices, the substantive remedy that could consider all of the contentions raised herein would lie by filing of an appeal in terms of section 179 of the BBMP Act 2020. Needless to state, you would be required to make deposit in terms of section 148(3) of the BBMP Act. The next, learned counsel for the petitioner has contended that in terms of section 144(16), 144(16), the respondent BBMP cannot traverse beyond orders passed 5 years after filing of tax return. Under this 5 years after filing of tax return. In light of such contention raised, which is a matter to be taken note of in appeal, it may not be appropriate for the respondent BBMP to insist upon statutory deposit as envisaged under 148(3) insofar as such of the years as falling outside the scope of 144(16) as is made out by counsel for the petitioner. Next. In light of relegation of the petitioner to avail of substantive remedy of appeal under 179, which appeal is to be filed within 30 days, as undertaken by counsel for the petitioner. The respondent BBMP not to take any precipitative action pursuant to the impugned orders challenged in the present writ petition till consideration of their application for interim relief. All contentions raised herein are kept open to be raised in the appeal proceedings. Accordingly, petition is disposed of. Which is that other matter, just give that, we'll keep that format. Yes.
First over matter, serial number 25, Nanesh Kumar K.
Lord, I appeal
Paying for respondent.
The principal.
Lord, my submission would be, my lord, I have received a sanction plan on 16/2/23, my lord. I have got a complaint from the neighbor called Deepak, and 12/6/23, my lord. For the spot inspection, my lord, I can able to identify there is a deviation. And the day itself, I have issued 248(1) and 2, my lord. Lapse of 12 days, I have issued 248, 3, my lord, on 21st, 6/23, my lord. They have challenged the 248.3, my lord, before Appellant Authority Commissioner, my lord, the appeal number 8024, my lord.
Appeal
And
number?
appeal got dismissed,
Appeal number
8024, my lord.
18 of 24.
80 of 2023, my lord.
8023, my lord.
80.
8023, my lord.
80.
80.
Ah.
And appeal got dismissed, my lord, on 21st, 1/24, my lord. In between, my lord,
Appeal is dismissed on
21st, 1/24.
21st of
My lord, my instructions are that, my lord, the appeal was filed in July 2023.
Huh?
Please.
No, it's coming from the horse's mouth. Let
My
it come
lord,
from
12, 1/24, my
Huh?
lord.
21st of
12 of January 24, my lord.
12th of January.
12th of January.
24 appeal is dismissed.
Dismissed, my lord.
Then what? So
And in between, my lord, 356 also issued, my lord, the budget estimation for the demolition, my lord, 3.92 lakh, my lord.
no, that when was the appeal filed?
Appeal filed on 4/7/23, my lord.
4/7,
23, my lord.
4th of July 23.
Yes, my lord.
Why you did not mention in your writ petition regarding filing of appeal?
And one more submission, my lord, even after issuing 248.3, my lord, at the time of issuing 248.3, there was, the construction was only ground floor and basement, my lord. And they have carried out the full construction, my lord.
For that you are to blame. Yes, now why you have not mentioned regarding filing of appeal?
My lordship, they have taken consent that they have not served the copy of the provision order, my lordship.
Huh?
So they have violated the principles of natural justice,
No.
my lordship.
Forget that. Where have you mentioned you have filed an appeal? Is there any averment that you have filed an appeal? Then it has to go on that ground.
My lordship.
No sympathy.
It's my lordship.
So I can't help it. You should have mentioned that you have filed an appeal. Not having done so, only on that ground of suppression of material facts, it will go. Now, since already they filed, final order is passed, you challenge that in
No, my lordship, that appeal has been withdrawn, my lordship, not dismissed.
Huh?
I have a copy of my. I have endorsement, my lordship. My lordship, on 30th of December, I have filed memo for withdrawal, my lordship.
Correct, but what is the final order passed? So you challenge that in accordance with it. That's all.
At least it should have could have been considered, my lordship, my memo, my lordship, before passing that order.
Correct. When you are filing the appeal, you challenge in that. When you are filing the appeal challenging that order, you seek for appropriate relief. Let us see. But then you have completed the construction.
No, I have not completed, my lordship. I have not completed.
How many floors are there?
So third floor is, second floor is going on, my lordship.
Lord, may I submit, my lord?
They
Sanction
have
plan
given
is
notice
G+3, my
while it is
lordship.
on basement and ground floor, my lord. It has
Thank-
reached to till third floor, my lord.
Sanction plan is
G+3, my lordship.
Sanction plan, we have,
G+3.
G+3, my lord.
Kindly look at page number.
No, let us see. I'm not going into the merits of the.
My lord, may I make one submission, my lord?
Yes.
My lord, let them not continue with the construction, my lord. That is the only request, my lord, that I'm making. Because, my lord, in the light of the interim order, my lord, they carried on with the construction, and in a span of 40 days, my lord, 2 floors have been raised, and day in and day out work is being carried out, my lord.
My lordship, I am constructing the as per a plan, my lordship, I am not violated.
That's for the
My lord,
BBMP. Let us
please,
see.
I will leave it to your lordship. That is the only humble request.
Petitioner has filed a writ petition seeking to quash the notice at annexure C dated 12/6/23, provisional order at annexure D dated 12/6/23, and confirmation order at annexure E dated 21/6/23, passed under 248(3) of the BBMP Act 2020. Full stop. The counsel for appearing on behalf of now you appear for?
He is not a party to the
My
proceedings.
lord, I have filed an including application, my lord, which is pending consideration, my lord. IA number 1/2024, my lord.
And Counsel Nandish Patil appearing for the impleading applicant has submitted that the writ petition is to be rejected on the sole ground that an appeal was filed against the order under 148(3), and said fact has not been revealed in the writ petition. Next, learned counsel for the respondent BBMP would submit that as against the order under 148(3) of the BBMP Act 2020, appeal was filed on 4/7/23, and same has been dismissed by order dated 12/1/24. And accordingly, it is submitted that the relief sought for in the present petition does not survive for consideration. Next. Insofar as the non-disclosure of filing of appeal 80 of 23 against the order under 148(3) of the BBMP Act, learned counsel for the petitioner would only submit that certain procedural violations, including violation of principles of natural justice, having occurred in the present matter, accordingly petitioner has directly approached this court. Full stop. Clearly, the submission by learned counsel for the respondent BBMP, which remains uncontroverted, that appeal 80 of 23 was filed against the order under 148(3). Full stop. Said appeal is stated to have been filed on 4/7/2023, which assertion is also not controverted. If that were to be so, question of filing the writ petition on 9th November 23 and seeking for setting aside of the order under 148(3), 248(3) does not arise and would also amount to an abuse of the process of the court. The non-declaration of factual material regarding filing of appeal against the very same order at annexure E which is challenged in the present petition would disentitle the petitioner for audience before this court. Next. Even otherwise, taking note that the appeal filed under as against the order under 248(3) has been disposed of on 12/1/2024. The question of continuance of the present proceedings does not arise. It is always open for the petitioner to seek for appropriate relief against the order passed in appeal disposing of the same on 12/1/2024 as per law. Learned counsel for the respondent BBMP submits that despite the order under 248(3), petitioner had carried on construction activity. And said submission it is submitted is being made upon instruction. Taking note that appeal itself is stated to have been disposed of on 12/1/2024. The petitioner herein is restrained from carrying on any construction activity till orders to the contrary are passed. Accordingly, petition is disposed of. You file a memo in which you mention date of filing of the appeal, date of disposal.
Liberty may be given, my lordship, to challenge.
That I've
Until then, no course steps have been taken, my lordship.
That you file and you get a stay.
My lordship, till 15 days, my lordship.
Construction should not
Otherwise,
be carried out,
they are
my
ready
lord.
to demolish the property, my
Construction
lordship.
should not be carried out.
That I've restrained.
Till at least 2 weeks, my lordship. Interim order may that order may be given, my lordship.
No, that you file.
At 2 weeks, my lord. There are anytime they will demolish the property, my lordship.
They will only remove whatever you have carried out during the pendency of the proceedings.
356 already has been issued, my lord. Even
So
cost
that's why
estimation
I'm
also has
asking
been
my
made,
lordship.
my lord.
No, correct. You have not come to the court with clean hands. Should you not? How did you? Who advised you to file an appeal and file a writ simultaneously?
My lordship, the validity is interim by the principal natural justice. That's why I approached the Sarma court, my lordship.
How can you do two parallel proceedings without even revealing the proceedings in this?
My lordship, at least at least 2 weeks that
you file it immediately.
No, my lordship, I will file it. So because I could not take there is saying that order has been passed. So I could not obtain.
We are asking you to remove the deviated portion, my lord, not the entire house, my lord.
2 weeks time is granted, my lordship. Till then,
you file it.
Definitely, my lordship, I will file it, my lordship. Otherwise, they will demolish the property. That's why I am seeking, my lordship. Requesting.
Now you can only remove. Don't demolish for about 10 days. Let us see. Let him take whatever steps he wants. But why should we give you any relief when you have not come to the court with clean hands?
At least my lordship. No, my lordship has
come to the court.
I left setback, my lordship.
No, forget all that on merits. You have suppressed the filing of appeal.
That's why I withdrew on the petition, my lordship. So before my lordship, on 30th of December, I filed memo for withdrawal. But without considering my memo, they have passed it on merits, my lordship.
You couldn't have continued with the. You shouldn't have filed a writ petition without declaring that you have filed an appeal. You're totally on the wrong side of law.
Yes, Master. I'll apply.
Yes.
My lordship.
Serial number
no
28.
protection. You have not come to the court with clean hands. Yes.
Also matter, serial number 28, Jesse Kumar.
This matter, the copy was given to me in the after lunch, post lunch copy is given. I could not take instruction. Can it be on tomorrow, my lord?
Tomorrow.
Anyhow, it is okay like that. Let them, we will reopen the law. Let them file an appeal. And 50% of the tax, my lordship, they can deposit to BBMP. In as my lordship have held in other matter, 334 of 2024. I will just take instruction and tomorrow we.
Tomorrow. We list the matter tomorrow in preliminary hearing list.
List number 2 matters, orders.
Pawan Kumar to take notice in the Land Council, Pawan Kumar accepts notice. Respondent 2 and 3, AG accepts notice for the first respondent. This is the matter in preliminary hearing list tomorrow.
List number 2, orders matter, serial number 1, A. Sampath.
For petitioners, my lord, 20,000 cost, my lord, we deposited today, my lord. I shall file the, along with the memo tomorrow. My lord.
20,000.
Please, my lord, for adjournment, my lord, we just, for adjournment, my lord, we took some, senior counsel was engaged, my lord, we deposited 20,000.
Week's time granted for necessary compliance.
No, we had already done, my lord. 20,000 is paid today. We'll file along with the acknowledgement by tomorrow.
Learned counsel submits that cost has been paid. That submission is taken note of.
And my lord, the
matter in B group.
Please, and regarding the tax paid receipts, my lord, that is also I filed along with the memo on 28th.
It's further submitted that tax paid receipts have also been filed.
Please, my lord.
Before this, before the registry.
No, it was filed in the open court. It was filed in the open court. It was also taken note.
Has also been filed.
Please.
List the matter in B group.
Please.
Week after next.
Interim order may kindly.
Interim order earlier granted is extended till the next date.
Please.
File a memo. It's not extended on the last date.
I shall.
It is submitted that due to bona fide lapse, interim order earlier granted was not extended on the last date. In light of the submission made and memo file, interim order earlier granted is extended till the next date.
Obliged.
Serial number 2, Anand K.
For the petition.
What is the cancellation?
But what happened, my lord? In the year 1917, kindly see the annexure B, my lord, page number 14. In the year 1977, the third respondent herein action the property belongs to the third respondent, which is action less than the 3,000 rupees, 5,000 rupees. And as per the rules, as per the provisions on section 72 of the Act, my lord, there is no need to seek a permission of the government or higher authorities, my lord. However, my lord, we thought that, my lord, they seek a permissions before the deputy commissioner. The deputy, they say that, my lord, they allege that the deputy commissioner rejected, cancelled the said actions, my lord. Therefore, they are not rejected our claim to execute the sale deed. And they kindly see the page number 15, where they are refer the deputy commissioner order. But however, I sought for the set copy from the deputy commissioner office. But they issued an endorsement. No such document is available. Therefore, this honorable court directed them to
regarding cancellation of
action, public actions. But as per the document endorsement issued by them, there is no such order passed by the deputy commissioner. Therefore, this honorable court directed initially third respondent, subsequently the government advocate to secure that cancellation order.
There is no cancellation.
No, man. I am myself also, I filed and kindly see the page number 20 annexure F. I also sought for the document of that cancellation. They issued an endorsement saying that no such documents is available in their. Illa anta. Cancel agidre, there should be a document. Even otherwise also there is no need, under section 70 subclass 2 says that, if it is any property as on that day.
Now let us see. Now we'll have it in B group and we'll dispose it.
Please, please, man.
This is the matter next week in B group.
Date.
Date
25th.
Oh, please.
Serial number 3, Mamta MR.
Appealing for respondent number 2.
Yes.
Appealing for respondent number 2, Your Honor. On the last date of hearing, we got served the notice, Your Honor. I mean, we need some instruction from the Taluk Municipality, Anekal, Your Honor. I pray for some time, so we'll file objections.
You appear for the authority.
Respondent number 2, yes, TMC.
At request made on behalf of respondent number 2.
Yes, ma'am.
List the matter after 2 weeks, statement of objections to be filed by then.
Lordship, one request, my lord, kindly date may be fixed, my lord. Since 12 years, my lord, the petitioner is fighting for compensation. Unauthorizedly, they used my land, my lord.
I think-
They have utilized my land. Till today, they have not paid any compensation. to them.
This is the previous.
They have made a road.
Lordship,
What have they used your property for?
constructed the overhead water tank, my lord. Since 1993, they utilized the property.
No, it was before the panchayat.
Kindly, my lord, in this case, date may be fixed, lordship.
No, but you have to pay, isn't it? Once you use the property, you have to pay.
The construction was made before the panchayat, Your Honor. After later, it came before the Taluk municipality, Anekal, my lord. We paid the 10,000 rupees for them.
10,000 rupees for
And they are
removal of
asking-
water tank, my lord. What these honorable court has directed the respondent number 2 to remove the water tank. ಅದನ್ನು ಕೂಡ ಅವ್ರು ಮಾಡಿಲ್ಲ. ಅದು ನನ್ನ ಕೈಲಿ ಮಾಡಿಸಿ ನನಗೆ 10,000 ಕೊಡ್ತಾರೆ. But they are denying to pay the compensation, lordship.
No, now compensation has to be paid. Whether government is going to pay, whether panchayat is going to pay, or you are going to pay. How are they concerned? You pay and recover from panchayat, that's all.
Yes, my lord. I pray. next
Delist the matter on date good.
1st of February.
1st of February.
Much obliged, lordship.
Obliged.
Serial number 4, KV Satish Chandra.
In the collected matter, I appear on behalf of the respondent. I have not been served with a copy of the writ petition, my lords.
In 4.1,
Please.
steps to be taken for service of notice to R3, R6 and R7. Petitioner to furnish, serve copies of the petition on council appearing for respondent.
Respondent number 10 minutes.
10.
As well as to respondent number 8 minutes. I am appearing for HTMC minutes in this
10
matter.
as well as respondent number 8.
HTMC. They are not served any copy minutes. Writ petition copy has not been served.
In so far as serial number 4, weeks time granted to carry out amendment and file amended petition. Yes, next.
Serial number 5, Vinayak B. Vishnu.
I appear on behalf of the petitioner, my lords. On the last date of hearing, this honorable court directed the CMC to file a report regarding the action taken against the respondent number 4 herein.
Yes.
This respondent.
The writ petition is to implement the notice dated 21/11/2022.
Annexure.
Annexure D2. Page 28. That is the notice issued to respondent number 4. The gist of the notice is you have taken permission for construction. It appears that construction is for the basement, ground and upper 3 floors. And the 4th floor, the terrace portion you have covered with the sheet. That should be removed. And at the setback, and this is page 28.
No, again, no, as regards notice at D2, you have submitted a reply.
A reply, after that, that was accepted. And the permission, trade license is issued. The case is that trade license should not be issued. Now the trade license has been issued. That
Well,
is,
annexure.
Lord, annexure R10, that tax is paid. R10 at page 39, 13 because.
No, but before that,
Yes.
after D2, your reply is at?
Reply.
or their acceptance of your reply.
Yes.
Annexure?
My lord, I am appealing for that too. I am filing the report.
Just wait, just wait.
My lord, an affidavit was given at R7, that is 10th October 2022, at page 28 of the statement of objection.
No, but then in terms of para 2,
Yes.
you have to comply with that.
That has been complied with. One is at the setback area, there was a small construction of the canteen that has been removed, that is reported. Another is.
Yes, what do you say?
There is the report, deviation as per.
Copy of the report has not been given to me.
Yes, sir.
No, if this is so, then they'll have to issue fresh notice.
First notice.
If the report says 31.95%, then you issue fresh notice, we'll record the undertaking and then close it.
Well, admittedly, there is a fourth floor which is against the plan, my lords.
Yes,
And my another contention is that they have not taken permission according to the fire safety norms.
No, that's so. That
also may not be.
no, that no. Who are you now? You are the neighbor, is it?
Please.
No. We'll keep it open. He has filed an affidavit at.
And in that affidavit itself, it may be kindly seen, my lords, at page number 29. They only say that they seek for time to demolish. They haven't stated that it
No,
has
it's
been
correct. Now
demolished.
they're making a statement that they've demolished. We'll make that observation. And in terms of the inspection report, they've found some deviation. We'll reserve them liberty to issue notice. And if there is any non-compliance with their undertaking at annexure R7, we'll ask them to include that in the notice if they which they may issue on the basis of the inspection report.
If I may, my lords, let that procedure go ahead and let them report compliance, my lords, and
No.
thereafter your lordship can take a decision.
That they will do. It's up to them to do. We'll record them and then let them take it forward and let the proceedings go on. Why we should keep this pending?
Please.
The petitioner has sought for issuance of writ of mandamus to implement the notice at annexure D2 dated 21/11/22 and has sought for an order of restraint against the respondent number 3, Panchayat, from granting trade license without compliance of the requirements under the Karnataka Panchayat Raj Act. Now trade license is granted.
Trade license was issued.
Issued.
Annexure?
Lord, they have not placed it before the court, but
They
I have placed the taxpayer receipt subsequent to that. That was issued on 10/3/2023. 1/3/2023. Trade license is issued.
The notice at annexure D2 records that
And okay, that is placed before the court at page 40. So the statement of objection. The license is placed on.
yes, the notice at annexure D2 is contains a reference to the resolution of the Gram Panchayat, whereby necessary action would be initiated as against the respondent number 4 as regards violations as noticed in annexure D2.
Yes.
Full stop. And counsel appearing for the fourth respondent submits that insofar as the deviations noticed at annexure D2, the fourth respondent has filed a affidavit, copy of which is enclosed at annexure R7, filed along with the statement of objection on 31st of August 2023, and in the said affidavit, certain undertakings have been made. It is submitted that there has been adherence to the undertakings made in the said affidavit, including removal of the temporary construction on the fourth floor.
Terrace floor.
On the terrace floor. Accordingly, it is submitted that question of issuing any direction insofar as annexure D2 does not arise. Third counsel for the appearing for the Panchayat, respondent number 3, has submitted a report stating that pursuant to the interim directions of this court, inspection has been done and there exists certain deviations. Contents of the report are relied upon. Full stop. Learned counsel appearing for the fourth respondent further submits that the prayer regarding trade license, issuance of prayer regarding prohibition of issuance of trade license sought for by the petitioner does not arise in light of trade license having been issued, copy of which is enclosed at annexure R10. Full stop. Next. At the outset, it must be noticed that insofar as the notice at annexure D2, taking note of the submission of counsel for fourth respondent that they have complied with. The third respondent is at liberty to take note of inspection report filed before this court, which would indicate deviation, to issue fresh notice regarding deviation from plan as is permissible under law. Full stop. Such notice may also take note of the undertaking contained in the affidavit filed by R4 at annexure R7 to the statement of objection, and if there is any deviation from the undertaking at R7 while issuing a notice on the basis of inspection report, said aspect may also be a subject matter of notice to be issued to R4. Full stop. Insofar as a trade license already having been issued, if the no orders could be passed, if any person is aggrieved, they are at liberty to challenge the same in accordance with law. Accordingly, petition is disposed of. All contentions are kept open.
Well, admittedly, according to the respondent number 3, also there is a violation.
So now they are
Instead
issuing.
of,
Now they are going
if I
to
may
issue
say-
notice for that. Let him that will follow the statutory scheme.
My lords, regarding the fire safety norms also it is.
That I don't, that will see.
No difficulty at all.
No, that will see, that I will not enter into. Anyhow, I kept it open for them while issuing notice to include all deviations. Yes.
Serial number 6, Narsimurthy GV.
A lot of applications filed by the sixth respondent. Only in the rectification is office is raised objection.
Notice has to go, or your on the IA notice has to go, or what?
Ali, notice agಬೇಕು.
Notice has to go. What is the office objection raised? Weeks time granted to comply with the office objections. If office objections are complied with, notice to be issued. IA 1 of 24 to IA 3 of 24. Yes.
Serial number 7, urgent. Serial number 8, BC Venkatesh.
The respondents 1 to 3, my lord.
For the respondent.
May kindly grant me some time, my lord. Inadvertently, I could not conduct the inspection.
Yes, list the matter week after next. Date for it.
31st.
Deeply obliged.
Serial number 9, Rupesha B.
Appear for petitioner, my lord. Weeks time granted to take necessary steps. Stay granted. Interim order earlier granted is extended till the next date.
Serial number 10.
Appear for the petition.
Yes.
The respondent stated that they will file objections or not. Right, in meanwhile, this court has taken the view that similar orders, they are quashed by this honorable court with liberty to file objections. Right? The other side is not here.
Is the matter next week?
Interim order to be.
Interim order earlier granted is extended till the next date.
Please.
Serial number 11.
You have to file appeal finally.
This court has actually come out of violation of principles of natural justice.
I passed orders considering all that directions. You can raise that point also in the appeal only. Anyhow, let us see. That's the stand I'm consistently taking. Yes.
Serial number.
This court, I'm saying this court also. All that you have to raise it there. We can't intervene at that stage.
They are doing it. In fact, today, the minister has taken cognizance and directed them to stop this. It has appeared in the paper.
Let us see, let us see. Yes.
Serial number 11, Shivaraju MK.
Weeks time granted to do the needful.
Proxy counsel on behalf of petitioner Miller, kindly give me short.
Weeks time granted to do the needful.
Serial number 12, Ajit A. Shetty.
Weeks time granted to do the needful. Interim order earlier granted is extended till the next date. Huh? Third Council Sri T.I. Abdullah is directed to accept notice for the fourth respondent. Yerduko. Third and fourth respondent. Yes.
Serial number 13, Mohammed Tahir.
Appearing for petition. In this case,
Yes.
make my submission. In this case, Lordship, notice has written in respect of respondent number 2 is unclaimed, Lordship.
Weeks time granted to take fresh steps.
Lordship, main party is the BBMP and we have already served the notice. Lordship, kindly consider deemed to be a service. Lordship.
No, what is the prayer?
He is denied, Lordship.
What is
she is
the
not-
prayer you have sought for?
See, we are trying to transfer the khata in our favor, Lordship, petitioner favor. We have already obtained the sale title of this property from the sale certificate of
Who
sale.
is the second respondent?
Second respondent is a daughter of defaulter, Lordship.
Daughter of?
Defaulter. Defaulter of loan. We have received this property through sale certificate, Lordship, from the bank.
Why have you made second respondent as a party?
She has wrongly misleaded the parties and executed the gift deed, Lordship.
Who?
Defaulter has executed the gift deed in the favor of her daughter. And in records, it's showing her daughter name, Lordship. Records ಅಲ್ಲಿ ಅವ್ರ respondent number 2 name ತೋರಿಸ್ತಾ ಇದೆ ಅದಕ್ಕೆ we have made the part.
You have challenged Now, your application.
We have filed the application to transfer the title in our favor, Lord. Transfer the khata. Application is at page number 19, my lord. And respondent number 1 BBMP has given the notice that on 15/10/2020, the respondent number 2 has respondent number 2.
But then what is the solution to this problem?
Now, intentionally tagonta illa notice. We have already paid the we have already paid the process. Unclaim anta barta ide tagonta illa intentionally. We have all bank also registered the criminal case on respondent number 2. Kindly consider refer the annexure F, lordship, page number 32. Cheat ಮಾಡಿದಾರೆ ಅಂತ ಬ್ಯಾಂಕ್ ಅವರು ಆಲ್ರೆಡಿ FIR ರಿಜಿಸ್ಟರ್ ಮಾಡಿದ್ದಾರೆ ಅವ್ರ ಮೇಲೆ ಗಿಫ್ಟ್ ಡೀಡ್ ಮಾಡಿರೋದು ರಾಂಗ್ ಅಂತ. ಅದಕ್ಕೆ ಅವ್ರ ರೆಕಾರ್ಡ್ಸ್ ಅಲ್ಲಿ ಅವ್ರ ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 2 ಡೀಟೇಲ್ ಹೆಸರು ತೋರಿಸ್ತಾ ಇದೆ ಅದಕ್ಕೆ.
In light of the submission that FIR has been registered against the second respondent.
Second respondent as accused number 4 in page number 33, Lord.
Notice to be served to the second respondent through the jurisdictional police. Necessary steps to be taken by the petitioner within a week's time. But then what is the solution, you'll have to see.
Yes, so I will also take instructions and make some.
Now, if they have already executed gift deed,
then they have to challenge it.
Let us see. You examine the legal position also. Yes.
Serial number 14, Anil Kumar R.
That would be in addition to notice through court once again. That would be in addition to notice through court to R2 through court.
Serial number 14.
I pay of the petition. I pray for week's time, my lord, I'll take steps.
Week's time granted to take necessary steps. Yes.
Serial number 15. Sunil Narayan Naik.
Here for the petitioner, Your Honor. I pray for week time, Your Honor, as personal inconvenience to my senior.
That request.
Interim order to be extended, Your Honor.
Pray for 2 weeks time, Lord, on this matter.
This is the matter after 2 weeks. Interim order earlier granted is extended till the next date.
Number 16, 17 urgent. Premiering B group matters. Serial number 18. Patil Dayanand.
For the petitioner, pray for short accommodation. Senior counsel like my lord.
Request made on behalf of the petitioner. Relist the matter on date good.
1st of February.
Oblige me.
Serial number 19 urgent. Serial number 20. Rajaditya Sudashivam.
For the petitioner, my lord, writ of mandamus to direct the respondents to consider my application. I had made an application complaining certain violations in a building sanction that has been sanctioned to my neighbor. My application has not been, it has acknowledged receipt, but they have not acted upon it at all.
Yes, BBMP.
Karthikeyan BS.
He's seeking for a consideration of his representation to take action against building violations.
Can I have it next week? I will inform him to take instructions.
So let him see if there is any deviation, let him issue notice, we'll record it.
Yes, sir.
Also, deep excavation happening. Kindly a date may be fixed, my lord.
Relist the matter in the preliminary hearing list on date
23rd.
I will inform him.
Yes.
Serial number 21st. Prasanna VR.
Number 3 and 4. Short accommodation.
At request.
Immediate notes.
Relist the matter on
31st.
Yes.
Serial number 20. Serial number 22. Balakrishna MR.
My lordship, the writ appeal is pending, my lordship. The same subject matter, writ appeal is pending, my lordship.
The writ petition based on which we sought mandamus is pending before the
Writ appeal,
Honorable
my lordship.
List
CJ.
the matter after disposal of WA 978 of 22.
Yes, my lordship.
Serial number 23, Sangamesh RB.
Serial number 21. I'm referring for the urban and art book.
Serial number?
21. 21. R1 and R2. The date is given on 31st. Kindly have the matter on 1st February.
1st of February. 21, 1st of February.
Serial number 23, Sangamesh RB.
Again, no mandamus are included. Some undertaking that you will take
For
action
petitioners.
under 248.
So the petitioners have filed objections to the report, my lordship. I will just go through it.
Forget about the report. Now, they've given a representation for you to take action against some building which they say is being built contrary to sanction plan. Now, what is the report you have filed?
One submission. So what has happened here is petitioner and respondents both are claiming the same property. They have an OS case.
Same property.
Same property. They have there is an OS case also pending against which
First appeal is pending.
RFA is also filed.
Even the
So
status
that
quo
is
is
where
operating.
we are stuck, my lordship. Respondents are in possession. Petitioners are claiming that it is their property. So that is how it is juggling between them.
Let us see.
The RFA status quo is also operating.
Now, let us see. Let us see. Is this matter in B group after 2 weeks?
Filed objection.
You settle your disputes amongst yourselves.
Filed objections. Report.
Objections filed to the commissioner report is taken on record. You have to settle your disputes. Don't bring it here and bring the BBMP into it. The RFA, you settle it and get whatever order you want. In the RFA, settle your disputes. Why you want to draw the BBMP into this dispute? Let us see. Yes.
Serial number 24, Raja L.
Yes.
Umayaji.
I have challenging the orders Annexure K, my lord. Of Executive Officer. The petition is a suit property is the owner of property, my lord.
Contesting respondent. Who's the contesting respondent is served or no?
Third objection ಹಾಕಿದ್ದಾರೆ statement of
ಖಾತಾ entry or what?
ಖಾತಾ ಎಂಟ್ರಿ ಅಲ್ಲ ಪ್ಲಾನ್ ಸ್ಯಾಂಕ್ಷನ್ ಮಾಡಿ ಎಲ್ಲ ಮಾಡಿ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಮಾಡುವಾಗ ನಮ್ಮ ಪ್ಲಾನ್ ಸ್ಯಾಂಕ್ಷನ್ ಮಾಡೋದನ್ನ ತಿರಸ್ಕರಿಸಿ ಮಾಡಿದ್ದಾರೆ. ಆಲ್ರೆಡಿ ಅವರೇ ಪ್ಲಾನ್ ಸ್ಯಾಂಕ್ಷನ್ ಮಾಡಿ ಗ್ರಾಮ ಪಂಚಾಯತಿ ರೆಸಲ್ಯೂಷನ್ ಮಾಡಿ ಈ ಖಾತಾ ಆಗಿ ವಾಟ್ ಎವರ್ ಏನ್ ಸೇಲ್ ಇಡ್ ಪ್ರಾಪರ್ಟಿ ಇದೆ ಅದಕ್ಕೆ ಪ್ಲಾನ್ ಸ್ಯಾಂಕ್ಷನ್ ಪ್ರಕಾರ ಸ್ಯಾಂಕ್ಷನ್ ಮಾಡಿದ್ದಾರೆ. ಸ್ಯಾಂಕ್ಷನ್ ಮಾಡ್ಬಿಟ್ಟು ಇದು ರೆಸ್ಪಾಂಡೆಂಟ್ 5 ಇಲ್ಲಿ ರೋಡ್ ಇತ್ತು ಅಂತ ಹೇಳ್ತಾರೆ. ದರ್ ಇಸ್ ರೋಡ್ ನಮ್ಮ ಸೇಲ್ ಡೀಡ್ ಅಲ್ಲಿ ಅಥವಾ ಅಡ್ಜಸ್ಟೆಡ್ ಓನರ್ ಅಲ್ಲಿ ದರ್ ಇಸ್ ನೋ ಸೇಲ್ ಡೀಡ್ ರೋಡ್ ಅಂತ ಎಲ್ಲೂ ಇಲ್ಲ. ಎಲ್ಲ ಪ್ರಾಪರ್ಟಿ ಇದೆ. ನಾವು ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಆಲ್ರೆಡಿ ಕಂಪ್ಲೀಟೆಡ್ ಆಲ್ ಗ್ರೂಪ್ ವೇಶ್ ಆಗಿ ಎಲ್ಲ ಆಗೋದು. ಈಗೇನಿದ್ರು ಆಮೇಲೆ ಫೈಲ್ ಸಿವಿಲ್ ಸೂಟ್ ಹಾಕಿದ್ದಾರೆ ಅವರು ಆಲ್ರೆಡಿ ಬಿಫೋರ್ ದ
ಸಿವಿಲ್ ಸೂಟ್
ಪೆಂಡಿಂಗ್ ಇದೆ. ಇನ್ ಅನೆಕ್ಷರ್ H ಮೈಲ same respondent filed a civil suit against me.
Suit for
mandatory injection. ದಾವಾ ಶೆಡ್ಯೂಲ್ ಸತ್ತನ್ನು ಪೂರ್ವ ಪಶ್ಚಿಮ 6 ಅಡಿಗಳು ಮತ್ತು ಉತ್ತರ ದಕ್ಷಿಣ 9 ಅಡಿಗಳ ಅಷ್ಟು ತಿರುಗಾಡಲು ಬಿಟ್ಟಿರುವ ರಸ್ತೆ ಓಡಾಡಲು ವಾದಿಗೆ ತೊಂದರೆ ಕೊಡದಂತೆ.
This suit is filed on
2023.
Now, what is the order passed by the executive officer?
The executive annexure K, my lord. Operative position 46, my lord.
ಮೇಲ್ಮನವಿದಾರ ಮನವಿಯನ್ನು ಸಮಕ್ಷ ಪ್ರಾಧಿಕಾರ ಪುರಸ್ಕರಿಸಿದ್ದೆ. ಸದರಿ ವಿವಾದಿತ ಆಸ್ತಿಗೆ ಸಂಬಂಧಿಸಿದ ಎರಡನೇ ಎದುರುದಾರರು ಒಂದನೇ ಎದುರುದಾರ ಹೆಸರಿಗೆ ಈ ಸ್ವತ್ತು ಖಾತೆ ನಮೂದಿಸುವಾಗ ಉತ್ತರ ದಕ್ಷಿಣ 66 ಅಡಿಗಳಷ್ಟು ಪೈಕಿ ದಕ್ಷಿಣ ದಿಕ್ಕಿಗೆ ತಿರುಗಾಡಲು ಬಿಟ್ಟಿರುವ 6 ಅಡಿ ರಸ್ತೆಯನ್ನು ಕಳೆಯದೆ ಉತ್ತರ ದಕ್ಷಿಣ 20-11-68 ಮೀಟರ್ 66 ಅಡಿಗಳ ಈ ಸ್ವತ್ತು ಖಾತೆಯನ್ನು ನಮೂದಿಸುವುದನ್ನು ಪರಿಗಣಿಸಿ ಸದರಿ ಖಾತೆಯನ್ನು ರದ್ದುಪಡಿಸಿ ಸದರಿ ಈ ಸ್ವತ್ತು ಖಾತೆಯಲ್ಲಿ ದಕ್ಷಿಣ ದಿಕ್ಕಿಗೆ 6 ಅಡಿ ರಸ್ತೆಯನ್ನು ಕಳೆದು ಒಂದನೇ ಹೆಸರಿಗೆ ಮತ್ತೊಮ್ಮೆ ಈ ಸ್ವತ್ತನ್ನು ಖಾತೆಯನ್ನು ನಮೂದಿಸಲು ಸೂಚಿಸಿದೆ. ದಿನಾಂಕ 2/3/22 ನೀಡುವ ಕಟ್ಟಡ ಲೈಸೆನ್ಸ್ ರದ್ದುಪಡಿಸಿ ಸದರಿ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದ ಕರ್ನಾಟಕ ಗ್ರಾಮ ಸ್ವರಾಜ್ಯ ಮತ್ತು ಪಂಚಾಯತ್ ರಾಜ್ಯದ ಕಾಯ್ದೆ 311 ಕರ್ನಾಟಕ ಪಂಚಾಯತಿ ರಾಜ್ ಅಧಿನಿಯಮ 1993 ಅಧಿನಿಯ ಪ್ರಕರಣವನ್ನು 64 ಕರ್ನಾಟಕ ಪಂಚಾಯತಿ ರಾಜ್ಯ ಕಟ್ಟಡ ನಿರ್ಮಾಣ ಮೇಲೆ ಗ್ರಾಮ ಪಂಚಾಯತಿ ನಿಯಂತ್ರಣ ನಿರಸನ ನಿಯಮಗಳಿಗೆ 2015 ಮಾದರಿಯ ವಿಧಿಗಳಂತೆ ಸೂಕ್ತ ಕ್ರಮ ವಹಿಸಲು ಭಾರತೀಯ ನಗರ ಗ್ರಾಮ ಪಂಚಾಯತಿಗೆ ಸೂಚಿಸಿದೆ. ಫಸ್ಟ್ ಆಫ್ ಆಲ್ ಅಪೀಲ್ ಅಲ್ಲಿ ನಮ್ಗೆ ನೋಟಿಸೇ ಸರ್ವ್ ಆಗಲಿಲ್ಲ. ಐ ಪ್ರೊಡ್ಯೂಸ್ ದ RTC in my lord without notice to the petitioner passing the order.
No, that you find out. Find out if whether notice is served or not.
Order sheet is produced, annexure J, my lord.
Annexure
J, page number 43. ಇಷ್ಟೇ ಆರ್ಡರ್ ಶೀಟ್. No notice, sir.
ಅಲ್ಲ ಆರ್ಡರ್ ಅವ್ರು ಬರ್ದಿಲ್ಲ. He has given pointers how order must be written. Now we can do one thing. We'll set aside K. We'll set aside K on the ground notice is not issued. And that no reference is found in the order. And then we'll say, in light of the suit filed between the private parties, after the disposal of that, necessary action may be taken. The
Contested for third.
ಅವು ಬರ್ದಿದ್ರೆ ಅವು ಅಷ್ಟೇ. The petitioner has now anyhow admittedly there is a suit wherein they have sought for removal of the structure not to obstruct the road, etc. We'll observe that and keep that open. The petitioner has challenged the order at annexure K dated 16/12/22 whereby appeal by the respondent
3 minor.
By the respondent number 3 herein before the executive officer Taluk Panchayat has been disposed of in terms of the order at annexure K, cancelling the kata registered in the name of the petitioner.
Petitioner.
Herein. Counsel for the petitioner
annexure B
would submit that there was no notice served on the petitioner and relies on the order sheet at annexure J. Further, it is submitted that between the petitioner and the third respondent, civil dispute is pending in OS 26/2023, whereby third respondent has instituted a suit against the petitioner herein, seeking for the reliefs for order of injunction not to interfere with the right of the third respondent in utilizing the road, order of restraining the petitioner herein from putting up any construction on the said road, comma, appropriate order for removal of the construction put up on the scheduled road. Schedule is the road, isn't it?
No road, my lord.
Alla, according to them.
Them in suit.
It is submitted in light of such prayer sought for and suit pending. Question of the municipal, the local authorities
on submission
passing any order on the appeal of the third respondent ought not to be permitted. We'll stop.
ಖಾತಾ ಈ ಖಾತಾ ಆದ್ಮೇಲೆ ಪ್ಲಾನ್ ಸ್ಯಾಂಕ್ಷನ್ ಆಗಿದೆ, ಪರ್ಮಿಷನ್ ಆಫ್ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಗೆ ಲೈಸೆನ್ಸ್ ಇಶ್ಯೂ ಮಾಡಿದ್ದಾರೆ ಎಲ್ಲ.
Let us full stop. Next. In so far as the contention at regarding non-service of notice, order sheet does not contain any reference regarding issuance of notice nor service of notice on the petitioner hearing. In the absence of any contra material produced, contention regarding non-service of notice requires to be accepted. If that were to be so, order at annexure K is liable to be set aside on that sole ground. Taking note of the civil suit OS 26 of 23 pending between the parties, that is the third respondent and the petitioner hearing, and taking note of the prayer sought for as referred to above, after the conclusion of the proceedings before the civil court, parties are permitted to move the authorities for appropriate relief. Accordingly, petition is disposed of. Order at annexure K is set aside. All contentions are kept open. Yes.
Serial number 25, Program Kadambi.
It's appearing on behalf of the petitioner. My lords, the OTS, BPMP has given us an OTS proposal. Now what happens, my lord, I'm a PSU. I have around 400 acres of land, my lords. There are several institutions, hospitals and residential units, my lords. So I've replied to that OTS proposal given by BBMP. They're yet to revert back on that, my lords. We intend on settling the matter.
So even for BBMP tax, there's OTS.
Yes, my lords. Like how they have done it for HL, they've informed us that they're willing to let go of the interest and we are negotiating. Now only issue is there are hospitals and other such institutions. So that anyways you are liable to pay less tax compared to other commercial units.
Relist the matter after 2 weeks.
Please.
My lord, serial number 32, I could not hear, my lord.
CM Nagbhushan.
My lord, serial number 32, I could not hear the matter when it was called up.
Serial number?
32, my lord. I appear for respondent
We are
number.
26. We are at 26.
Oh, sorry, my lord.
Yes.
My lord, in this matter, my lord, I am appealing for respondent number 2 and 2 to 4, my lord. Raise short accommodation to file statement of objections, my lord.
What is the matter?
The matter is in spite of the decree of the trial court and the first appellate court. Kata is not my name. All that I am seeking is as per the sale deed dated 1949 under which my grandfather purchased to make a kata in my name. And they tried to interfere this village panchayat. I filed a suit that has been decreed in my favor. They filed an appeal that has been dismissed. All that is done, they are not making a kata.
On what ground we are not making kata?
My lord, they have encroached some extent of land, panchayat land, my lord. It is there at annexure E and E1, my lord.
It is on that ground they passed an order, your lordship. They refused to pay kata. Thereafter, they interfered with my possession. I filed a suit that has been decreed, your lord.
Suit against the?
Writ petition against the second and third respondent, your lord.
No, suit is
Suit is against the second and third respondent, your lordship.
No, then once the civil suit is decided, How can you again say encroachment?
Please, my lord, to take some instructions, my lord. Why? Because, my lord, they encroached some extent of land from
Correct.
panchayat, my lord.
Now
Please,
that was the subject matter of the suit.
please, my lord.
That encroachment,
Please, my lord.
you could have raised it in the suit. That's considered. Their allegation of encroachment is considered, is it?
Page number 29, your lordship, the trial court records. Plaintiffs have been in possession and enjoyment suit property as per all the documents produced by them. At page 29, your lordship.
We'll have it in preliminary hearing list. You take your stand.
Please, my lord.
Now you can't keep it pending without taking any action.
If I have encroached, your lordship, what is the remedy? They should file a suit to recover that land, not to refuse to make a kata.
You take, that right will be kept open in case you feel that they've encroached. That you can go
It's
to
clear,
the.
my lord. It's clear at annexure E1, my lord.
That is their document.
86, my lord. Page 86, my lord.
Now you file whatever you want to file. I'll give you 10 days time and fix a date.
Please, my lord.
In preliminary hearing list, we'll dispose it of.
Please, my lord.
List the matter in preliminary hearing list on 29th.
Much obliged.
Now, if there's any encroachment, you are at liberty to take action in accordance with law.
No.
But once a sale deed is given, you have no option but to take note of the registered instrument and the civil court decrees.
Please.
Much obliged.
Cell number 27, Purnachandra M.
Say, appear for the petitioner in this case. Challenged annexure R1, your lordship, wherein the respondent number 1 passes an order saying that all powers now stand vested with the state government. Annexure A is at page number 16, your lordship. The petitioner's grandfather is actually the owner of a 10 by 10 shop. That shop is taken away by the respondents for construction of a bus stop. By virtue of the land which has been taken away, there is an agreement at Annexure B, which is entered into by the grandfather of the petitioner and the respondent number 2.
No. Now the property belongs to whom?
It does not belong to me. I am paying rent to the government. I am paying rent to the respondents.
Rent to the government?
Yes, Your Honor. To the respondent number 1, there is receipts to the same.
Huh?
Lordships, the position and the adjacent lands have been given away for market rate, and the same submission has been reiterated in page number 32 by the letter of respondent number 2. Page number 32, last paragraph, the respondent number 2, Directorate of Municipal Administration themselves write to the government saying, ಲಾಸ್ಟ್ ಪ್ಯಾರಲ್ಲಿ ಅದರಿಂದ ಪುರಸಭೆಯಲ್ಲಿ ವ್ಯಾಪ್ತಿಯಾಗಿರುವ ಕುಂದಾಪುರ ಗ್ರಾಮದಲ್ಲಿ 101 ಸರ್ವೆ ನಂಬರ್ 10x10 ಚದರಡಿ ಸ್ಥಳವನ್ನು ಶ್ರೀ ಚಂದ್ರಶೇಖರ್ ಬಿನ್ ಲಕ್ಷ್ಮಣ್ ರಾವ್ ಇವರಿಗೆ ಮಾನ್ಯ ಸರ್ಕಾರ ಆದೇಶ ನಂಬರ್ ಡೇಟೆಡ್ so and so 260.
Take your stand in writing. The AGA is directed to file statement of objections within 2 weeks. List the matter thereafter.
Your lordship's date may be fixed. The
Fix admin date.
Obliged.
5th of February. Serial number 28, Lalita P.
Yes.
My lord, in this case, we have already issued 356, my lord. It has been approved. We have sent for the cost estimation, my lord. Once it is cost is fixed, my lord, we will take action in accordance with law, my lord.
They have not filed appeal.
They have filed an appeal, my lord. It is dismissed on 20th 5/23, my lord.
They have obtained an interim order before this court.
Yes, my lord. They're challenging the appeal, my lord.
There is no plan.
No plan, my lord. An 100% deviation, my lord. Their contention, my lord, they're saying it is like 10 years old property.
Rules are framed for 240 clause 8, is it? Huh?
There is no
248.
plan, they can apply for the plan.
Apply.
But it is 100% deviation, my lord.
The rules framed or
Penalty and how much is to be done, that is not.
that's not there. So how are you exercising that power?
As if now, none of the plan is sanctioned as per my instruction. When I have not come across,
This is not there in the old act.
no, it's a new act. When there is no plan, you can apply. But if there are deviation or some extra flows are constructed, that cannot be regularized.
But then there's some direction for you to consider.
This one.
Some direction for you to consider. No representation on behalf of the petitioner. So you consider, if it's not, you reject it. 14/8/23, an order is passed. Directing consider under 248. You consider and pass orders on that.
We'll have it next week, we will verify whether they have applied it or not.
The respondent, the petitioner is not available.
No representation on behalf of the petitioner. We list the matter on. Yes.
Serial number 29, Anand V.
For respondent number 3, Your Honor. Nothing for respondent number 1 and 2. Pray for 2 weeks' time.
List after 2 weeks at request.
Serial number 30, urgent. Serial number 31, H. Mohan Kumar. Serial number 31, H. Mohan Kumar.
Dispute between the
Huh?
dispute between the petitioner and the third respondent.
List after 2 weeks.
Serial number 32, Shishidhar SP.
I appear for respondent number 7 in this matter, my lord.
Yes.
I undertake to file wakalat for respondent number 7, my lord. I pray for a short accommodation to file my objections.
Even the municipality will have to file objections, my lord. Even I too seek for, my lord.
Statement of objections to be filed by the respondents. Learned counsel
Apeksha,
Apeksha undertakes to file wakalat for R7.
please, my lord.
Yes.
Nishant, the name may kindly be deleted, my lord.
Registry to delete the name. Who appears for?
I appear, my lord. I have filed wakalat.
Learned counsel M.A. Subramani has filed wakalat for respondents 4 to 6.
For 6 I have filed, my lord. I take notice on behalf of 4 and 5 also.
Undertakes to appear on behalf of respondents 4 to 6. Office to delete the name of learned counsel E.V. Nishan as appearing for respondents 4 to 6.
Serial number 33.
ಆ ಕಡೆ ಇದು sound ಸ್ವಲ್ಪ ಇದೆ ಆ ಕಡೆಯಿಂದ ಮಾತಾಡೋದು. ಅದೇನು ಕೇಳಿ.
Serial number 33, Manmohan PN.
Here for the petitioner, my lords. Only short point is that the petitioner approached this honorable court on a because of the threat of demolition by the BBMP after issuing confirmation order. We had already filed appeal and it was not listed. Before the matter get listed, the BBMP we had a threat, so we approached this honorable court, and this coordinate bench was pleased to grant interim order restricting the BBMP from demolishing the property until the appeal is heard and disposed of. Appeal is pending and it's coming up on 20th for hearing.
So we'll dispose it off, making this interim order absolute.
Yes, my lords.
Subject to the decision of appeal, we will take action.
Yes, yes.
Yes, my lords.
The petitioner has sought for, has assailed the order dated 19/10/23 at annexure E,
Page number 48.
which is an order passed under 248(3). It is submitted that in light of the statutory remedy of appeal against the order under 248(3), under section 253(3), petitioner has preferred an appeal before the Chief Commissioner. And same is pending consideration. This court had earlier noted the submission in the order dated 17/12/23 that appeal was filed by the petitioner and had restrained the respondent from taking any coercive steps against the petitioner's property till appeal is heard and disposed of. Taking note that an appeal is filed and pending consideration, wherein the order under 248(3)
Lords,
is a subject matter of consideration.
appeal was filed before filing this writ petition.
The petition itself is disposed of. Making the interim order absolute, whereby the respondent is restrained from taking any action to pursuant to the order under 248(3) till the appeal filed by the petitioner challenging the said order is disposed of in accordance with law. All contentions are kept open. You had mentioned in your
Yes, my lords, at page number 8, my lords, of my petition, para number 5.
Once a paragraph mail. Learned counsel for the petitioner submits that the petitioner was constrained to approach this court despite having filed appeal before the Chief Commissioner, as interim relief was not taken, and the interim relief sought for regarding the order under 248(3) was not considered.
No, my lords, the matter was not listed for hearing.
As the appeal was not taken up for consideration, and consequently interim relief sought for was also not considered.
Grateful.
Serial number 34, Ajay Prabhu M.
Though, my lordship, there is a earmark road in my lordship, it's in my lordship master plan of 9 meters. My lordship, the respondent number 3 has filed writ petition before this honorable court, stating that, my lordship, the respondent 1 and 2 are seeking for further extension of road. Actually, that is not the case, my lordship. There are existing, my lordship, 9-meter road.
No, now what is the relief you are seeking?
Yes, my lordship. My lordship, they had filed a writ petition before the honorable court without making, my lordship, the petitioners as a party.
What is the order passed in that writ petition?
Yes, my lordship. My lordship, annexure A, my lordship, page number 23.
Page?
Annexure A, my lordship, order.
Correct. Now
That is what their condition is.
page 30.
Page number 26, my lordship. Writ petition.
Correct. Annexure A.
Yes, my lordship.
What is the operative portion?
Operative portion is in my lordship page number 30. Writ petition is allowed, the circular is issued, order dated 27/12/2022. At annexure A passed by resolution number 1 is passed. By my lordship, it is passed, my lordship, at the insistence of the residents nearby, my lordship, neighbors of resolution number 3.
What is the 27/12/22 order?
Yes, my lordship.
No, now, who pleadings are complete?
No, ma'am.
Yes, your lordship,
Hmm.
this order, if you were to peruse the.
No, have
code-
you filed your objections?
No, your lordship, this once they got it listed and this is the first time we are appearing, your lordship.
Let them file their
No,
objections.
your lordship, prior to that, if you were to peruse the prayer, your lordship, the prayer is recall the order dated this passed by this honorable court. Your lordship, this essentially is a review of the order.
Correct.
It has to be heard by the bench that originally passed the order, because otherwise this bench would essentially sit in appeal over the decision of the coordinate bench.
Yeah,
Also,
no?
your lordship,
Not that, madam.
No,
your
ma'am.
lordship,
So just 1 minute. If you suppose a person is not a party and a writ petition, just 1 minute.
yes, your lordship,
Suppose a person is not a party and a writ petition is disposed of.
yes.
Now, the petitioners herein were not parties in 3894 of
No.
20,
Yes, your lordship.
isn't it?
Yes, your lordship.
So some orders passed. According to them, they ought to have been heard. They have some grievance.
Yes, your lordship.
Then the remedy opened for them is to file a separate writ which would amount to a review of the earlier order. But it's not necessarily a review petition.
Your lordship, there's one fact I'd like to bring to the notice of the court. When this petition was heard, your lordship, my learned friend himself appeared before the court with an impleading application.
No. No.
Your lordship, I'll let me finish. He submitted that he may be permitted to file the impleading application, narrating the same facts which he filed right now, which he presented right now. And the court was not at all inclined to accept it, called him a busybody and said that it would impose cost on him because.
Was any order passed?
Nothing is.
Your lordship,
Was any order passed rejecting his application?
your lordship, he said that if you would file this impleading application, I will put costs on you, is what the observation that was made in the open court, your lordship.
Oral observation.
Because your lordship, the court felt that he was a
Lordship,
busybody.
Correct. Those are all our oral observations. Now you contest this on merit. You take your stand, we'll consider it. If according to you.
They cannot deny me.
Just 1 minute.
Please, I'm sorry.
If according to you, even otherwise on merits, he is not entitled for audience, either because he doesn't have a locus standi to challenge the subject matter of the writ petition, we'll consider it. You take it in writing, we'll consider.
Yes, your lordship.
Statement of objections, if any, filed by the respondents within 2 weeks.
Yes, your lordship.
This is the matter thereafter.
Let me fix, my lord. Because, my lordship, in terms of the order of this honorable court, the respondent 1 and 2 has issued a building license to the respondent number 3. It is, my lordship, it is literally, my lordship, encroaching upon the public road.
2 weeks are my date.
6th of February.
Yes.
By then file whatever you want to file in writing.
Yes, your lordship.
Please. We are not concerned about more than, my lordship, 9 meters of road, which is earmarked road in the master plan.
Let us see.
Please.
Serial
Both
number-
have to file.
Yes, lordship. Grateful, lordship. Serial number 35 adjourn. Serial number 36 dismissal for non-prosecution matter. Amresh A. Angadi.
Good. This court had passed an order on 27/11/2023, which reads as follows. Next. Despite the matter being listed under the caption dismissal for non-prosecution, there is no representation on behalf of the petitioner. Taking note that the petitioner is not diligent in prosecuting the proceedings, Petition is dismissed for non-prosecution.
Yes.
Okay. 30. 56. The court notice over this. 36. It is stated that the counsel for the petitioner has passed away. In light of the same, issue court notice to the petition. The early order cancel.
With the kind permission of my lords, may I make one? Serial number 31, I couldn't be present at that moment. I am seeking for a
The number
31.
Which list?
Second list. I am for the petitioner. A date may kindly be given.
Other badla, at request.
Next one.
Is the matter on dates 31st.
Please.
ಅಯ್ಯೋ ಎಕ್ಸ್ಟೆನ್ಷನ್ ಆಗೋದು ಬೇಡವಾ ಅದನ್ನು ಕೇಳಿಲ್ಲ ಅದು ಹೇಳ್ಕೊಡ್ಬೇಕಲ್ಲ ಪ್ರಕಾಶ್ ಸರ್ ಹೇಳ್ಬಿಡಿ ಒಂದು ಅಯ್ಯೋ ಎಕ್ಸ್ಟೆನ್ಷನ್ ಮಾಡಿಸ್ಬಿಟ್ಟು ಹೆಂಗಿದೆ ಅದನ್ನು ನೀವಿಲ್ಲದ್ರೆ ನಾವು ಹೇಳಂಗಿಲ್ವಲ್ಲ